Okay, hearing none, we'll move
Oh,
forward.
yes, sir. This is Keegan Miracle. I would like to request a set over.
Okay, we'll call your case. This is the Rebecca Castiato and Keegan Miracle matter. I'll
Yes,
ask
sir.
Ms. Castiato, is it, if you're on the line?
Yes, I'm here.
Okay, very good. Let me just take one moment to pull up my notes. All right, this is a motion brought by Ms. Castiato regarding contempt involving child support. It looks like service was proper. So I'll hear from Mr. Miracle as to the basis for your request for continuance.
Oh, yes, sir. I just haven't had enough time to respond. I literally just had a death in the family, and my grandfather's still on his deathbed. I'm just asking for like a week set over so I can properly file and respond to the contempt.
Okay. Ms. Castiato, what's your position?
That's fine.
Okay. Yeah, it seems like a reasonable request, and so I'll grant that request. Next week is pretty full, so I'm going to set it over 2 weeks. We will move the case to that date, and we'll look forward to receiving Mr. Miracle's pleadings, and then we'll go from there. Thank you.
Thank you.
Any other requests for continuance or set over?
Thank you.
Yes, Your Honor. This is Brendan Lovato. We've come to an agreement outside of court and just kind of wanted to suspend everything until we can get that resolved.
Is Shanice Lovato on the line? This is Ms. Lovato. Oh, Ms. Lovato, you're there?
Yes.
Okay, great. So it looks like this is on today for Ms. Lovato, your motion to reinstate child support. What's your position?
Yeah, so we have been talking. He said that he's trying to refinance his truck right now, and that a court-ordered child support would mess all that up for him. So I'm trying to work with him right now, and the only thing that I would be actually like asking is that, because sometimes he does block me on random occasions when he doesn't get a proper response that he wants to hear. So I just want to make sure that the girls' Social Security gets put into my name and not going directly to him.
Your request is that what be put in your name?
The girls get Social Security every month, and he's at the moment still receiving that. So I just want that to be switched into my name, which he said that he would do it, but he still hasn't done it. So I just want to make sure that gets done.
Okay, so let's. I appreciate that. Let me just back up a little bit. So with regard to the motion to reinstate the child support that's docketed for today, Ms. Hastings, are you asking that be postponed or stricken? And then
I'm gonna postpone it for now, just to see if we can communicate better, and he holds up to his side. Bye, girls. Have a good day. Dad, sorry, I'm dropping kids off from school.
Okay.
Okay. 1 second. Sorry.
So as far as a continuance time frame, what amount of time? What's your input as far as how much time should be? How far out should we set it out?
Let's do like maybe the end of next month.
Mr. Lovato, what's your input on that?
Yeah, that would work fine, Your Honor.
So that would be April 24th. That's the last Wednesday in April, April 24th. How does that look for each, Ms. Hastings?
That should work.
Okay, Mr.
Yeah,
Lovato.
Your Honor.
Oh, sorry, Mr. Lovato. The audio is a little garbled.
Yes, that will work fine, Your Honor.
Okay. All right. And then, Mr. Lovato, what's your stand or viewpoint regarding Ms. Hastings' request regarding the Social Security income?
Yes, that was already going to be transferred to her. It was just she tried it on her own, and they said that she couldn't do it, so I have to be the one to do it, and I just have to get around to calling them, which is something I need to do this week.
Love you. Bye. Love you. Have a good day.
So is that something that you will accomplish by the end of this week?
Yes, I should. There should be no reason why I don't get that at least transferred over there. I just need her information, and then it'll be done.
Okay. All right, Ms. Hastings, any other comment regarding that?
I don't think so. The only other thing that I want to bring up is so all three girls are supposed to be back in my care. My oldest daughter, she's in high school, and she asked me to be able to just finish out the school year in Alabama, and I agreed to that. But Mr. Lovato is trying to say that he's going to try to keep her there after the school year, even though my daughter and we already agreed that they're going to be full-time with me. So I just wanted to make sure that like he's not going to try to pull anything at when I go and pick her up.
Okay, so that's a separate issue than what we're addressing here today. We're on for the motion regarding the child support. There was issues raised regarding the Social Security income and the transfer of that. As far as any prospective actions that may or may not occur, there's a court order related to the transfer of the children. If the parties want to agree to something else, you can. If there's concerns that something may or may not happen or something has happened, then certainly you can file a motion related to that. Generally, the court doesn't get into prospective rulings of something that may occur. If you feel like an order is necessary, then you'd need to file a motion related to that. So today I'm not going to make any rulings related to what may or may not happen.
Okay, I think that was it.
Okay, Mr. Lovato, any other items?
No, Your Honor.
Okay, we'll see everybody back on April 24th. Thanks for your help.
All right, thank you.
For a continuance, but my microphone was muted.
Oh, Ms. Brady, hold on one second. I've already called the next case. We'll handle this case and then you can chime in thereafter.
Okay.
All right, Mr. Zandy.
Good morning, Your Honor. All for presentation today. There's Mr. Robertson, I see him now. Basically, we just need a little clarification from the court. I think we're largely in agreement with the proposed orders. We just need some insight related to a potential right of first refusal provision in there. Granted, we didn't specifically argue that either way a couple of weeks ago when you heard argument from both parties on this, but in consideration, and I think that GAL and or my client made a good point about that we would just as soon see a right of first refusal be included in that parenting plan under paragraph 14 for any period exceeding 6 hours or longer. A reason for that, again, we did discuss significant differences in work schedules. Also, the ages of these kids will require them to be in daycare, largely over father's otherwise residential time under prior paragraph of the parenting plan, number 8. So we're just asking that the court include a right of first refusal that's mutual, that works for both parties in any period of time in excess of 6 hours.
Thank you. Mr. Roberts.
Good morning, Your Honor. My memory and my notes show that the court did address the right of refusal at the last hearing. I'm sure the court recalls that this is a case which the parties don't get along as well as we want them to, and as well as they likely will in the hopefully soon future, but we're going through a rough patch. And the court stressed that simplicity was primary at this point. My notes from the last hearing, no right of first refusal after opposing counsel's request is what I have in my notes. I don't know what the court has in its notes. I have not reviewed any video of the hearing, but those are the notes that I made at the hearing last time, and it's consistent with my client's recollection of the conversation we had. So I understand that a right of first refusal is requested, but we're on for presentation, and my understanding is the court already made that ruling.
Work schedules. So you're taking 2 young kids, and they're going to end up in, I think, primarily daycare over dad's time. Do we necessarily want to do that, or do we want to write a first refusal in there?
The right of first refusal, I'm just a little bit concerned about that. Kind of to your point, and maybe a little off to the side, is the preschool. The preschool is an issue. I know one party wants it 2 days a week, the other wants it 5 days a week. As far as the work schedule, I'm going to leave it as it is, as I've rolled on a temporary basis. We'll see how things go.
Even if the court is going to reconsider it, and I don't believe there's a proper motion for reconsideration, but if the court's going to have this conversation and make a decision, the situation is one where exchanges have been fraught with more than should be the case. And I know the court's very well aware of that. That's why exchanges have been at school, and we're trying to move things towards the most neutral, limited time, limited energy, limited frequency situation possible. So I think we're inviting significant conflict. And one of the issues last time where I was concerned, and I think the court shared some of it, but I was concerned that if Miss Furlong was emboldened to not collaborate because she didn't want the 50-50 to reinstate, and the court did so, and this looks like another attempt to say, well, if Josh is working and his grandma could take care of the children, and that's a common thing that family does when a parent is at work for 4, 5, 6, 7 hours. There's no reason why the child needs to go back to mother, have another fraught interaction exchange with the parents. And this looks like Miss Furlong didn't get what she wanted the last hearing, and this is an attempt to chip away at a few more hours here, a few more hours there. So the 50-50 is not really a 50-50 unless my client takes Thursdays off work, which he can do, but I think that the court made a ruling last time and we should stick to it.
All right, thank you. Ms. Height, do you have any input on the issue?
Thank you, Your Honor. I do believe that it would be in Declan's best interest to have Thursdays outside of such a structured environment that he is having now. That my thinking about it is that for the rest of the school year, it would probably be in his benefit to not be in a structured environment for those 3 days in a row, that he would have that Thursday free of that structure that seems to be stressing him out at the current time. So that's I'm seeing it as a school year issue rather than a forever type issue.
So with regard, do you have any thoughts related to right of first refusal, any recollection of the hearing and or input?
I'm sorry, were you asking me, Your Honor?
Yes, sorry.
I remember that it was discussed. I do not remember anything precise about it.
Okay, thanks. Mr. Zani, any final thoughts?
Just very briefly, I think there has been, unfortunately, some hiccups since this joint plan has been put into effect. It's again kind of coincides with what our somewhat perceived arguments were at the time. These parties have a ways to go, and again, these are very young children, so it's not about leaving. Grandparents are not parents. Parents should take obviously priority over grandma or grandpa, and my client is available to do that and act in the same capacities that she has throughout these 3 children's young lives since they were born as a primary caretaker. So again, I think it's a practicality argument. I did look back through the clerk's minutes, and it looks as though there was some discussion about that, but I don't see any specific ruling given. It states Mr. Zandy addresses right of first refusal, court responds, but I don't see anything beyond that, and I think that's just where we need some clarification and direction moving forward.
Okay, thank you.
I would briefly just mention, and I apologize, Your Honor, that parent-teacher conferences are this afternoon. I don't know when Ms. Furlong's having hers, but my client is dealing with that this afternoon. So I think we're going to have some more information on the school situation very shortly, and the term is ending in, well, a couple of months. Anyway, that's all I have.
All right, thanks. All right. Thanks for your input. I appreciate that. I'm looking at proposed orders that were filed by Mr. Roberts, and those are the orders that you're referring to, Mr. Sandy, when you're making reference to paragraph 14, correct?
Correct.
Okay. As far as the right of first refusal, I'm going to hold off on granting that. I did take a look at the notes of the clerk's minutes. Oftentimes, when an issue is addressed and there's an affirmative ruling on it, there's, the court, the notes will usually say, court makes a finding and it says yes or grants the right of first refusal, where it says it's addressed and the court responds. That my sense there is likely that it was not granted. My personal notes don't indicate that clearly, because I think that was something that was addressed during the hearing as opposed to something that was maybe fully developed in the pleadings. So I'm going to hold off on that. And then I'm going to grant that order that was submitted by Mr. Roberts. Mr. Roberts, did you provide a hard copy to the court? Because I have the one that was filed.
I apologize. I'm not familiar with how Your Honor, want things to be done. In the future, if you want me to send 2 copies, one to the clerk's office and one to you, I didn't realize that's your preference, so I apologize for that.
No, I mean,
you may not have one.
I mean, if you submitted to the court clerk, that's perfectly good and well. We don't
Okay.
To, but I was just looking. I'll look again at the notes.
There's a hard copy we mailed to the clerk's office, and they may just have the original in the court file, but I don't know if you have that court file, which may have been my mistake. But tell me how you want it in the future, and we won't have this hiccup again.
Oh, okay. All right. The clerk indicated that if it's clearly marked that this is a working proposed order, then they won't file it, and they'll keep it separate and apart. What we can do here, the proposed order that was filed, I can simply print that off and sign off on that.
If you'd like an email or anything along those lines, I'm happy to do it, but noted for the future.
Okay, yeah, I'll just print it off and sign it. Okay, I think that concludes the hearing. Thank you.
Thank you, Your Honor. Have a great day.
Thank you, Your Honor.
All right, there was one request, I think it was from Ms. Brody. You were making a request related to a request for continuance or striking.
Yes, that's correct. My person that is supposed to be serving him properly or whatever is having trouble locating him. I guess maybe he'd be at work or something when they're trying to see him or something. I'm not sure, but is that still required if he has everything he needs for the case? Or
Ms. Brody, I'm going to ask you to repeat that and speak a little more slowly and enunciate a little more clearly. I had a tough time understanding what you're saying.
my speaker's broke. I said he hasn't properly been served by my side yet. The person that I have over there trying to serve him is they're having difficulty being able to meet up with him at the same time, or whatever, if they're working or he's working. So does he still need to be served, or?
Okay. So just let me touch base with you all. Let me ask if Ivan Molina is on the line. Ivan Molina, are you on the line or in the courtroom? Ivan Molina. Mr. Molina, if you are here, make sure you're unmuted and please state your name. All right. Looks like he's not in the Zoom call, nor is he in the courtroom. So, Ms. Brody, this is your motion, correct, for restraining order and temporary orders related to parenting plan and child support, correct?
Yes.
And I show that there's personal service by the Island County Sheriff back on February 2nd. Do you see that, or you're saying that there was other items that still need to be served upon him?
These the one we're doing court right now for the new things that I filed, restraining order and temporary placement, or what one was it? Yeah, those ones I thought that I was supposed to have them served.
Yeah, that's true. So I'm looking at. So on February 1st, there was a motion for immediate restraining order and a declaration of Summer Brody and immediate restraining order. All those documents were sent from our county up to Island County's sheriff's office for them to serve. And then on February 28th, this Island County Sheriff's Office filed a declaration indicating that they served those documents on Mr. Molina.
Okay.
On that date, or on February 2nd, it looks like. So so I'm sure we're here for the restraining order. It looks like you served a copy of that along with your declaration accompanying that. And then it looks like, as far as then the parenting plan and child support issues, not seeing maybe that's what you're talking about there, that he hasn't been served on that. Is that correct?
Yeah, the most recent stuff is pretty much what I'm talking about.
Okay. So as far as getting him served those documents, how confident are you that you can get him served, or is that pose an issue?
It's an issue because it's like 4 hours away.
Okay.
Yeah. So, and I don't know his work schedule. I don't talk to him actually currently at all.
Okay. There's a couple ways to approach that. One, we could set it to a future date in hopes that the service is effectuated, or the service can be effectuated, and then you could give him notice as to a date, and then you could note it back up for a particular date. Do you have a preference?
I don't have a preference. I mean, I would like to push it out, or I mean, for a little bit, because I don't even know anything if he has an attorney. He said he was getting an attorney. If that's the case, I'm probably gonna try to have to get one too. But my daughter doesn't want to be anywhere near. So.
Okay. So okay, hold on a second. So the temporary restraining order is in place, and it was set for the 21st for a hearing, and Mr. Molina was present at that time, so we continued it to today's date.
Yeah.
And again, is Ivan Molina here? Ivan Molina. So I think, so not hearing a response from him. So I think what needs to happen is that if you're making a request to continue, then that restraining order that was temporarily put in place would expire today if it were not if it were not extended. So if we continue the matter, then I think we need to set it to a date certain and extend that temporary restraining order until that date. So,
Okay, can you clarify for me, because the clerks keep telling me, make sure I'm aware it's not a protection order, it's a restraining order. What was the difference? How am I protected with my child? Or not protected? No.
So on February 1st, there was an immediate restraining order that was imposed, and it protects Summer Brody and Aliyah, and it restrains Mr. Molina from taking the child out of the state of Washington until the hearing. The children are to live with Summer Brody. There's a little bit of ambiguity on the stay away order in that it says, the stay away order says do not go within 2,000 feet of the protected person's home, workplace, vehicle, school, or daycare of the child. And there's, and then there's also a restraint of not threatening or hurting or harassing or stalking you or the child. So
yeah, which another thing, they have this social media thing going on telling people that I'm kidnapping my child, and people are actively like making crazy statements about me with my pictures and everything online, and my child's pictures.
So in the restraining order, there's no restraint regarding social media. Okay, so that order's in place, and it was set over to the 21st. We were here. I don't see that it was renewed at that time, so I think we need to make a renewal of that order, and then we'll set it over. What period of time are you asking for, Ms. Brody?
So he still needs to be served. And can I serve him by public, like by mail, or no? Is that not allowed?
There needs to be personal service unless there's an indication that that's not possible. Then an alternative means could be provided.
Yeah, I can't go up there at all, and I don't know how else to do it. I can keep trying my contact up there. She can keep trying when she's not at work. So 3 weeks maybe.
Okay. All right. Give me just one moment, please.
Yes, sir.
Your Honor, I believe that we're also ready for a continuance.
I'm not finished with the first case. Hold on. Okay, Ms. Brody, I'm reissuing the temporary order that was initially issued back on February 1st. We'll schedule this matter for a new hearing on April 3rd of 2024. In this restraining order, it'll need to be served on Mr. Molina again, and so I've asked that the Island County Sheriff, our clerk's office, will send this up to the Island County Sheriff's Office, and they'll make attempts to serve him.
Does it show if there's an attorney in his case, or is that? Or
Could
we
you
still?
repeat that, please?
Does it show if he has an attorney already,
Nope.
or do I?
No attorney has filed a notice of appearance, so he's representing himself pro se.
Okay. Because I was told that I serve him at the service attorney if he has one or something. Okay.
So we'll come back on April 3rd at 9 o'clock in the morning to hear that restraint order, and also you'll need to make sure that there's service on him of your motions. I'm making an indication here that yes, you can serve him your motion related to the temporary orders. You can serve him by U.S. mail.
Okay, great. Thank you so much.
So we'll see you on April 3rd at 9.
All right, thank you. Have a
Present
good
in the
day.
courtroom. Thanks. Good morning. Come on up and just take a seat. And if you could just position yourself in front of the microphone, just get it close to your mouth so we can hear you clearly. And then Natasha Bicker, are you on the line?
Yes, sir.
Great. And did I pronounce your last name correctly?
Bakar.
Bakar, thank you.
Yeah.
All right. We're here on, I believe this is Mr. Canales' motion related to transferring the matter to mediation, correct?
Yes, sir.
All right. Ms. Bakar, it looks like you're currently at WCC.
Yes.
Okay. And then you're going to be released sometime in January of next year?
Yes, sir. January 27th.
January 27th. Okay. And then want to double check. When I looked at the file earlier, Mr. Canales, it indicated that at least I didn't see a return of service on Ms. On Ms. Bakar related to your motion. Did you send her a copy of your motion and serve it
Yeah,
upon?
she should have got it by now, honestly. I sent it out a week ago.
Okay, Ms. Bakar, did you get a copy of that motion?
I have not got it. When when they get legal mail sent here, it takes like a couple weeks for me to get it because they have to process it and review it and do the whole process here.
Okay. Okay. Yeah, it looks like it's a one-page document. And then, Mr. Canales, did you sometimes when people have a document and then they have it served on the other party, they'll get the affidavit of service or a declaration of service. Did you get one of those from the WCC?
I don't believe so.
Because sometimes what'll happen is that you'll ask the WCC employee to make sure this is served upon Ms. Bakar, and then they will write out a declaration saying on such and such a date, I gave this document to Ms. Bakar, and then they'll send that back to you, and then you file it with the court.
I did get something back. I just have to, I didn't bring all my papers today. I just thought it was just going to be like an arraignment type thing scheduled for next court dates and stuff like that. Okay.
Yeah. So at this point, Ms. Bakar hasn't been officially served with your motion. And so it's the idea of this due process that everybody gets a chance to know what's happening and be heard. And so you've got your motion, you have your desires, and then she needs to have a copy of that so she knows what you want. And then when she knows what she wants, she could say, yeah, that's great. Or she could say, no, I don't want that. And then she'd file something in return and then send you a copy. And so then everybody has knowledge of what the other person's thinking or wanting.
I did send her all the paperwork and she sent me back, and that's why she sent me back the request of her wanting to do 4 in-person visitations and like 3 video calls and then free phone calls, whatever. And that's why I scheduled for the mediation.
Right.
So I did get that back. So
yeah. Okay. And so then so your point is, Mr. Canales, is that you sent up the motion to transfer the case to mediation, and you haven't received any documentation back. Is that your position?
Yeah.
Okay.
I called them ahead of time and they said they were going to call me back, but they haven't still yet called me.
Okay. That seems to comport with what Ms. Bakar is saying, is that they may have received it and she hasn't heard anything about it. You haven't heard any official word that they've actually got the document to her. How long ago was that? Do you know?
It's about like 2 weeks ago. 2 weeks ago, probably.
And Ms. Bakar, you said a couple of weeks is kind of the standard 2-3 weeks for processing?
Yeah, it's a whole process that it has to go through property, and then but the facility has been so short staffed that the property room hasn't been open, and when we get legal mail, we'll be put on the call out to go at 7 in the morning to pick it up. So it depends on once it's approved by the mailroom and stuff, they have set me an appointment to be served or to go pick up my legal mail.
Okay. Even though the motion is fairly short, it's a one-pager, right? And it makes reference to a local mandatory mediation rule. Even though it's short, that rule is fairly long, and so I think, so everybody's aware of what we're doing here today. I don't think we can move forward today on the motion just because the service hasn't been effectuated yet. There's a good chance, it sounds like, maybe within the next 2-3 weeks that'll be served. And then once it's served, they would send that copy back to you, Mr. Canales, which you would then in turn file with the court. So we know the circle's been fully made its way around. So let me just ask the parties as far as coming back, just to be on the safe side, April 3rd. I know that's a ways out, but it sounds like with the short staffing that may be appropriate. But how does that look for your calendar, Mr. Canales?
That's fine.
Ms. Bakar?
That's fine, but I asked that, so I almost wasn't able to appear at this court date because when you guys send a court, they have to, how do they send it? It has to be sent to the virtual hearing inbox here at WCCW, and I had to contact my attorney that was for my dependency case, and she got this set up, but she no longer works for the county. She's moving, Meredith Graff, so she sent the email to the virtual hearing. So I don't know how you guys do it, but it has to be sent to the hearings in order for me to appear.
Is there a specific email address?
You have the email address? Can she tell you it?
Sure.
What do I need to look out for, Your Honor?
Let's say again.
What do I need to look out for?
And so thanks to the DOC employee. Thank you very much.
Thank you.
And then we'll give the headset back to Ms. Bakar so she knows
Sounds
what
good.
you're saying.
Thank you.
Okay, so I think we've got the information we need, Ms. Bakar, so we can get you here on April 3rd. Then
Awesome.
Mr. Canales just asked, he said, no, what do I need to be looking out for?
Yeah.
I'm assuming that you asked that have that document, your motion sent to Ms. Bakar at WCC with some type of declaration form that they can fill out. If you didn't, you'd need to get that declaration of service affidavit or declaration of service up to them. So when they do serve her that document, they can fill it out and send it back to you. So it's a declaration of service.
Declaration of service. Okay.
All right, Ms. Bakar, any questions?
No, Your Honor, but just to clarify, when William sends me any mail, he has to send it as legal mail. And so I don't know if maybe that's a reason why I haven't received it yet, but we can't get legal mail through distro mail, so he has to label it legal mail.
Okay. Do you know how you sent it?
I just sent it regularly.
Just sent it. Oh, okay.
Papers, it was a yellow envelope.
Right.
And I just sent it like that because I didn't know if I had to do that or not.
Yeah. So Ms. Bakar, if he does that, if he just sends it just regular, will that get to you? Or will
they'll either hold it or they'll hold it and review it, or they'll send it back, or they could just be sitting in property. I'll kiosk today and find out. And if it does get returned, then he just has to label it legal mail, so that way it goes through the proper channels here.
Okay. All right. So
I know it's a process. It's kind of frustrating.
Yeah. So so it sounds like, just the kind of the difficulties with WCC and DOC and the like, that your motion, maybe you could do this, Mr. Canales, kind of do a fresh start. If you could get you get a copy of your motion, send that up to Ms. Bakar and put on it that it's legal mail, and then send up with that a declaration of service that they can fill out.
Okay.
If you go to, there's a website you can go to, it's courts.wa.gov, and just type in there and you can go under forms, and then you can just look for a declaration of service and it'll be right there and you can print it up pretty easy.
All right.
And if you can do that quickly, maybe today, that would be great. And then we can probably keep that same date, that April 3rd date, and hopefully we can expedite things and have your motion heard without further delay.
All right.
Any further questions?
No, Your Honor.
Ms. Bakar, any further questions?
No, thank you, Your Honor.
Okay, we'll be back on April 3rd at 9 a.m.
Appreciate it.
All right, thank you.
Thank you.
All right, not hearing a response. I thought I saw earlier today there was a message via Zoom making a request related to that, and I saw the name Granzo Carranza because it's a kind of a unique name.
Yeah.
Did you see that pop up on the screen?
I have not, but I talked to her yesterday because I served her that paperwork.
Okay,
and she said she was going to be here.
Okay, so it looks like there's a meeting chat there. What does it say? So there is a chat message there. It says, "Can we set the Ruby v. Granzo Carranza, as I just received the rest of the paperwork yesterday." So she's making a request, but I'm not sure where she's at now. Ms. Granzo Carranza, are you on the line? Let me check with you. So there's no response. So Mr. Ruby, do you know if she was served with all the documents?
Yeah, my friend Justina handed them all to her yesterday.
Okay. And has your friend filled out?
Yeah, I turned that in this morning.
Okay. Do you have a copy of it?
I do not.
So what happens with those documents? It would be a beautiful world if you turned it in and it goes right into the scanner.
Yeah.
It doesn't happen that way. There's some processing time involved.
Okay.
And so according to my file, I don't see it. It hasn't been uploaded, right?
Yeah. No, I just put it in there by keeping here.
Okay. So without that showing of that she's been served with that, oh, looks like she's coming in now. There she is. Ms. Granzo, if you can hear me, I see that you're there. I see that you're unmuted, but I can't hear you. So we saw your chat message that you're making a request to set the matter over, and you said because you had just received the rest of the paperwork, I think you said yesterday. So I wish we could hear you, because I really don't know what your position is. So let me touch base. So yeah, go ahead, Mr. Ruby.
She's wanting to come to like between me and her an agreement.
Mhm.
And I'm not wanting to do that. Every time we do that, it goes nowhere.
Mhm.
We've been through this process multiple times in the past.
Mhm.
And I'm just not doing it no more. It never.
Your Honor, I'm here.
Way.
Okay. All right. So Ms. Granzo, can you hear me okay?
Yeah, I just joined in, and the last half of what I just joined in on, I'm really confused because I was just served with the rest of the court paperwork yesterday, and had asked him if he was willing to sit down and talk over this, and he said yeah, but he was going to ask today for it to be set over. So I'm really confused.
Okay. So it looks like you received the documents yesterday, and that comports with what Mr. Ruby had indicated, that there's just a recent service of the documents. So with you just receiving the documents, there'll need to be an opportunity for you to respond to Mr. Ruby's position. So I think we probably just need to set this over 2 weeks to the 27th. That'll allow you time, Ms. Granzo, to file your response, Mr. Ruby to get it, and he can respond if you'd like.
I have an additional court date on the 27th.
Okay.
Is there any way we can do it
a different day?
Yes, sir.
Sure. So this is so in the case, Mr. Ruby and Ms. Granzo, you can chime in on this. Is there a temporary restraining order in place currently?
Yes.
No.
Well, there is. It's just some things weren't approved.
No, currently active there is not, because when he tried to put the restraining order on me about a year ago, he no-showed the court. So the judge striked the matter. So currently there's no active restraining order, temporary restraining order.
So notwithstanding the certainty of Ms. Granzo's position, there is a temporary restraining order in place. And the reason I say that is that, pull it up here. So on February 13th, there was immediate restraining order that was obtained via ex parte. And then on the 28th of February, that order was reissued until today's date. So it is still in effect. So with a request to set the matter over to allow everybody to see what the other side's position is, I'm going to reissue that protection order until.
Okay, so with that being said, I asked about that when we set this over last time, and the only thing it said that I was not allowed to take my kids out of Washington State. So what is the temporary order for anyway? Because I've seen both of my children in the last 2 weeks. I've been to Marcus's house to see Bethany. There's been communication. So in regards to the temporary order, what am I allowed to do and what am I not allowed to do? Because I've been.
Did you receive a copy of the temporary order, Ms. Granzo?
What I received from Klamath PD was a temporary order ex parte, but the ex parte was crossed out, and that's what I tried to clarify last time, and was told that I'm just not allowed to take my kids out of Washington State. So
So you can refer to the order, and the order is self-explanatory what the restraints are. Restraints are fairly limited in that it says, under paragraph 12, it says the petitioner and respondent must not take the children out of Washington State. The existing order of 10/21/2022 is in effect. There's an indication that there must not be a moving, taking, hiding, damaging, borrowing against, selling, or trying to sell, getting rid of any property. That's what the restraint is. So.
Okay, so then am I allowed phone calls? Like that's compared to how all the other orders.
October 21st, 2022 orders in effect. That's what controls.
Okay, so then there's no clarification as to what I'm allowed to do and what I'm not allowed to do.
So you can refer to the order for any specific.
I have referred to the order.
I will answer your question. Did you have a question for me, Ms. Granzo? Don't be impatient with me. I'm trying to assist you.
I understand that, but
Ms. Granzo, hold on.
No, fuck you guys.
Ms. Granzo, did you just say the F word?
I apologize, sorry. This is why I'm doing what I'm doing.
So, Ms. Granzo, I'll just remind you that you're in a court of law, and that's completely inappropriate and impermissible. And if you do that again, you could be held in contempt. Ms. Granzo, are you still on the line, or did you chicken out and leave? Okay. Will you please make sure that the record reflects that Ms. Carranza expressed profanity within the court hearing. She was warned of it, whether she heard it or not, I'm not sure. And that she exited. Thanks. So I'm reissuing that temporary order. We're setting the matter over to April 3rd at 9 o'clock in the morning. And Ms. Looney, you're here. Let me just hear from you if you have any additional information or requests.
No, nothing further to add, Your Honor.
Okay, thank you. So we'll be back here on that date, and then Ms. Granzo will have an opportunity to respond to your pleadings and requests, and we'll see you on April 3rd at 9 a.m.
Thanks, sir.
Thanks.
Yes, Your Honor.
Okay, welcome to you, Ms. Guy. And then Quincy
you.
Guy, are you on the line?
Yes, Your Honor.
Okay, welcome to both of you. Ms. Looney is here also.
Good
This
morning,
is
Your Honor.
that it's on today for a finalization of a dissolution. I've received some proposed orders that I'm just pulling up right now related to a variety of issues. So first off, let me turn the time to Ms. Looney regarding the proposed child support worksheets. Ms. Looney?
Thank you, Your Honor. The state has provided some proposed worksheets and a proposed order. Our interest in this case is as to medical support only, but as the parties are self-represented, we did that for the court to review. We used Mr. Guy's 2023 employment security data to calculate his income. He did work all 4 quarters for an average hourly wage of $20.46, and we calculated that at 35 hours for a net monthly income of $27.24. For Ms. Guy, we also used her 2023 income just for quarters 1 and 2, as that was all that was available. She did make an average hourly wage of $19.90. We also calculated that at 35 hours per week, and that gave her a net monthly income of $26.56. The proposed transfer payment that we came to for the standard calculation was $768 or $384 per child, and would be requesting that support begin starting April 1st. We have left some spaces blank in the order based on the proposed order received from the parents. There was some agreements that they had come to potentially that the state does not have an interest in. So we did leave section 9 to be filled in if the parents were requesting a deviation from that amount that the state had calculated for the transfer payment, as well as section 10, which would be to fill in the payment amount. Excuse me. We also left in section 11 as the parents had potentially agreed on a different schedule for being able to readdress child support, and section 19, which is regarding the tax exemptions.
Okay. All right, thank you. Could I hear from Ms. Guy what your position is related to the proposed child support?
Quincy and I had come to an agreement at the $400 a month, which he has been paying. So I don't have an issue with that.
Okay.
I know that the state has a different perspective, and I'm also okay with that. I am not here to try to make him pay anymore, though.
Okay. And as far as the start time, are you fine with an April 1 start date?
Yes, Your Honor, I'm okay with that.
And then do you have input related to the tax exemptions?
I would just ask that I be able to claim the children on my taxes indefinitely because they are 100% of the time with me.
Does Mr. Guy have visitation with the children?
On his own time. However, that is rare.
Okay. And he's been paying the $400 child support?
Yes, he has.
Okay. All right, thank you. Mr. Guy, what's your input related to child support?
So the child support we agreed on, I've been paying like was stated. As far as visitation, she does have them most of the time. But when I get to have them changes every so often, according to what she deems okay. So when she say that it's rare that I have my children, it's because if she says no, I'm not going to fight it. Obviously I would have to fight it in court, but I've just never been a fan of court. So if she says no, then it's no. And that's just where it is. So that's why I don't have them often. But as far as paying child support, I have no issue with paying it. I just feel like I need to be able to, pay my bills and live as well. So,
okay. So you're comfortable continuing to pay the $400?
Yes, I'm comfortable.
And what about starting on April 1 for an official start date for the court order of child support?
That's fine. I've been paying it. So,
okay.
It would just be a continuance of what I'm doing already.
And as far as the tax exemption, what's your opinion on that?
It's always been like that as far as her claiming them. And I've never fought that either. So I have no reason to fight it now.
So even though you're paying, roughly $4,800 a year for support of the children, of course, Ms. Guy is making expenditures for the children also. You don't want a tax exemption? Because tax exemptions bring cash into your pocket usually.
I want her to, have what she needs. And if that's something that she wants, then I don't mind her having that. Like I said, I haven't got it ever, so I'm used to just not getting it. So
Okay. Okay, thank you for your input. And Ms. Looney, any further comment on your end?
And I just wanted to confirm with the parties. I was just reviewing the order that they had proposed. The reasons we left some spaces blank is because the state doesn't have an interest, but the parents had potentially agreed. And section 11, they had, I believe I did put that in there, that they had the first Friday and second Friday for the payments to be due. Also in section 13, they had wanted to be able to review child support every 6 months, which is slightly different from typical Washington law. And so we wanted to confirm if they were still wanting to do that, so that could be filled in the order as well.
Okay. All right. Thank you. All right. Well, as far as the child support, let's just finalize that. The state's interest is, you indicated, Ms. Looney, the state's interest is limited to
just to the medical support, Your Honor. So we would not have an objection to changing the payment amount if the parents are agreeing to a different amount than what we have proposed.
Okay. So I'm fine making that change as far as the deviation here. Let me just, the parties agreed $400. It works for them. So let me just do that here. Mr. Guy, as far as the payment, do you usually just pay $400 all at once, or do you divide it up?
I'll usually divide it up.
Okay. So can you pay the half by the first and the second half by the 15th? Or is it a different date range work better?
Sometimes like this last month I got paid on the 6th, and then but I can definitely pay it every 2 weeks.
Okay. Ms. Guy, do you have any input on that?
I don't have any issues. He does always pay it. It is at different dates, but he's usually pretty good about communicating that with me. So I don't have any preference on due date. No.
Okay. I'll just I'll provide a little more wiggle room. I'll just say first payment by the first half of the payment due by the 7th, second half due by the 22nd.
That works.
Then there was an indication from Ms. Looney that you all wanted to be able to review the child support every 6 months. Is that accurate?
I believe I did that, and it's not something I'm super concerned with. Like if that's not Washington's normal protocol, I'm okay with doing whatever is the normal protocol.
Okay, Mr. Guy.
If whenever I can afford more and she wants to communicate about that, then I'm down to do that whenever.
Okay. All right. So I think what I'm going to do as far as that paragraph 13, I'm just going to make it that it can be changed according to state law. So I'm not going to set a specific schedule for it to be reviewed or changed. As far as the tax issues or the tax exemption, it sounds like the parties have agreed that Ms. Guy would claim both children every year. So I'll just put that here. Those 2 documents have been signed. Then let's turn our attention to the findings and conclusions about a marriage document that was submitted, looks like by Ms. Guy. Mr. Guy, did you receive a copy of that and reviewed that?
Yes.
Okay, and it looks like you signed off on that. Do you have any questions about what you signed or what that order does?
I wasn't, there was some things I was confused about, but as far as what I read, I agreed with.
Okay. Do you have any questions today?
No, Your Honor.
Okay. And do you still feel comfortable with this? You're having signed that document?
Yeah.
Okay. And then I'll ask you kind of the same questions related to, there's a final dissolution decree and also a parenting plan. Did you receive both of those documents?
Yes.
And it looks like in the same fashion, both of those documents have your signatures affixed to it. And do you have any questions about either one of those documents, what they say or how it impacts you?
Yes. So like we were just kind of talking about me having my children.
Uh-huh.
I want to make sure that when I'm supposed to have my children, I can have my children, and she can't say no about that.
Okay. Okay. Yeah, and what it has here, it says in this proposed parenting plan, it says the following. It says that Ms. Guy is the custodial or primary parent, and that since the children are 14 and 9, that it's under their school age children. So the children, it says, are scheduled to live with Kristen Guy.
Correct.
And then it says Quincy's schedule varies, so we work it out together when and if he's available. So in other words, there is no specific provision that says you get the children on such and such a date to such and such a date. So that means that there's really nothing here that says anything other than that Ms. Guy is the primary custodial parent, and there's no specific time reserved for you for parenting time with the children.
Okay, that would be something I want to change, because we originally did, but then it came to a halt when she told me no one time, and so it's kind of been off and on since then. I wasn't sure when I was able to be able to get them back. But if we could just fix that part of it, I feel like everything would be fine. And we were doing every other weekend, and I'm still fine with that. We could work in extra days if I can have them, but I at least want my every other weekend back.
Okay. Ms. Quincy, are you agreed with alternating weekends or no?
I'm sorry, Your Honor, are you talking to me?
Yes.
Okay. No, I don't have any issue with that. The only hurdle I see is that Quincy doesn't drive, and so getting the kids back and forth is typically on me, and I can't be held responsible to get them there and back at his beck and call. I would absolutely love to work something out with him where I bring them, he brings them back, or that he can be responsible for bringing them back or picking them up. And if we can come to an agreement with that, I would be more than happy to open up every other weekend. I would love for him to see his children more often.
Okay, so it sounds like there's some more work on this case to be done related to the parenting plan time and also the exchanges and who's responsible for that. So what that means is I think you all need to talk a little bit more and come to a particular agreement, because the orders that I have here today don't fill out all those contours that you're talking about here today, as far as like alternating weekends and who's in charge of the exchange and driving and the like. So I'm not in a position to sign off on those orders today. That you, as the parties, can note it back up again, or if you want me to set it out to a specific date where you think you'd be able to come to an agreement, and then you could submit new proposed orders, then we can move forward with that. So do you have any questions about that?
How early could we get back in? Because I think we could come to an agreement very quickly.
Probably on
I
the
agree.
3rd of April.
Can I ask a quick question? Does that mean that the divorce won't be finalized until the 3rd of April, or is it just the parenting plan?
Correct. It would not be finalized until that time.
So then, Quincy, I would ask you if you and I can just work this out outside of court and finalize today.
I was going to ask the same thing. If I was to sign off on this now and she gets that taken care of with the divorce being finalized, how soon could we change what we just signed into effect?
Yeah, so the child support's in effect. That's a done deal. As far as everything else, new orders would have to be submitted. And if the parties agree to that and you make some adjustments, and if you agree to it, then you could submit it simply, what they say, ex parte. If both of you have signed off on it, then both of you could sign it, and then it'd be presented to a judge and be signed off on. So
okay.
if you want to do that, that's fine, and then we won't schedule a hearing. If you feel like a hearing, it would be helpful to come back. But if you feel like you can come to an agreement, then you can simply get those documents to us, and they could, and both of you signing, and then it could be signed off on.
Okay. Well, I agree to everything today. I know she needs this done. So I'm willing to just revisit this afterwards.
Okay.
I would appreciate that.
Okay, so at this point, we won't schedule any additional any hearings. If the parties come to an agreement, you can submit that, and then that'll be signed off on. But if the parties don't come to an agreement, then if you want to have some type of finalization, then you'd need to note it up and have the court make a decision. Any questions on that?
No.
So once again, the divorce is not being finalized today then?
That's accurate. That's accurate. Yeah, because there's outstanding issues as far as the parenting plan and exchanges. And that's not agreed to. So without that agreement, then it's not finalized. But if the parties come to an agreement and that's specified in court orders and you both sign off on it, then it could be finalized promptly.
Okay, so I guess my question was, I was saying that I agree with it now, right? Does it say in the paperwork that we don't agree?
In the paperwork, it says that Ms. Guy basically has full control as far as parenting time, and there's nothing specifically reserved for you, so there's no protections there. And you said that you wanted to have the alternating weekends, and that Ms. Guy had concerns about the exchanges, and so if there's not agreement, then you all can talk about it offline, out of court, and then submit something if you agree to it. If you don't agree to it, then one or both of you would have to note it up, and then we can come back and
So what I was saying was I was agree for you to sign everything the way it is now, and me and her can revisit, the parenting plan after everything was signed, because she needs the divorce to be finalized. You understand? So I'm trying to work with her, hoping that she would work with me afterwards.
I will definitely work with you. I have no objection to Quincy seeing his kids. I want him to see his kids. Like he stated, I do need this finalized. I'm working on an adoption outside of this that's supposed to be finalized before April 3rd. So this is kind of the missing link. When it comes to Quincy seeing his kids, he's a good father. I don't have any objection to him seeing his kids, nor do I want to keep his kids away from him.
So just from my perspective, I don't feel comfortable with that open-ended parenting plan. The parties need to come to an agreement. I think there's just too much room for power and control and potential abuse. So I'm not going to sign off on it today. So if the parties want to come to an agreement, you're free to come to an agreement. If you can't come to an agreement, you can note it up for a future hearing. Thanks. Any more questions?
I'm on number one, Your Honor, and I believe it's going to be a quick matter.
Okay, and this is the Masudi matter?
Correct, and Miss Rebecca Ford is here. She's the other side. I was appointed on Friday, but I wasn't aware of that until Monday, and I'm asking that this matter be set over a couple of weeks, and I'll contact Miss Ford and see where we're at on an agreed order on adequate cause.
Okay. All right. So just make sure we have all the parties here. Mr. Agnosto is here representing Matthew Cox, and I'll ask if Rebecca Ford is on the line.
Yes, Your Honor, I am here.
Okay. So Ms. Ford, Mr. Anagnosto is requesting a continuance of the matter. What time frame, Mr. Anagnosto?
2 weeks would be fine.
So the request is that this motion related to your motion for an adequate cause and also modifications would be set over 2 weeks. Do you have any objection to that?
No, that's fine. And what time would that be, Your Honor?
9 a.m.
And I was wondering about that, Your Honor. Since I've been appointed, would this go to the attorney docket, or would it say on the pro se?
Yeah, that's a good point. Thank you, Mr. Anagnosto. It would be on the move to the attorney docket. So, Madam Clerk, I'm going to turn to you for some assistance as to the date or the day of the week and time. And this is ends in a 6 or a 0, actually. Thanks. Clerk's just going to double check to make sure we get it on the right docket. Tuesday. Would the 26th of March, that's a Tuesday at 9 a.m. work for the parties?
Yes, Your Honor.
Yeah, that works for me, Your Honor.
Okay, well, let's do that. We'll move it to March 26th at 9 a.m. and we can have the motion heard at that date and time. Desiree Kamba, if you're on the line, please state your name. Desiree Kamba. Right, there's no response. Ruben Kamba, are you on the line?
Yes, I'm here, Your Honor.
Okay. Well, the record reflect that Ms. Kamba is not in the courtroom, and nor is she on the Zoom call. I typed in her name. She's not present, and she didn't respond. Mr. Kamba, this is your motion related to adequate cause. Looks like service was proper upon Ms. Kamba, and there is your motion for adequate cause is granted, and your proposed parenting plan is granted. And I think you submitted some proposed orders, if I'm not mistaken.
Yes, Your Honor.
Yeah, let me find that here. Okay, so I see that here, an order on adequate cause to change the parenting plan. Let me just review that just a moment. And then did you submit a parenting plan also, Mr. Kamba?
I believe I did.
Okay, let me dig a little deeper. I've got quite a few documents in here, so let me make sure I have it. Okay, good. Thanks, Madam Clerk. So, Mr. Cameron, is that the clerk is indicating that the only document that she received as far as a proposed order was the order on adequate cause, and then we would need a separate parenting plan order. And I think, let me just pull it up here. I'm looking at this. You submitted one via, it's in the court file. You submitted it on February 22nd. Is that the document that you are hoping would be entered today as far as a parenting plan?
I believe so.
Oh, could you repeat that again?
I believe so.
Okay, thanks. So, so therein it says that you are the primary custodial parent. There's a limitation on Ms. Gamba that any visitation would have to be done with a supervisor, and it'd be from Sunday from 10 a.m. to noon, and that should be evaluated for mental illness and start and comply with treatment if recommended, that you have sole decision-making for school education and healthcare. And that her time is just limited to what we said before. The holiday schedule is the same as that Sunday schedule visit time. So that's the one that I have. Does that sound like the one that you're asking for?
Yes.
Okay. And I believe that's the same document that you mailed to her, correct?
Correct, Your Honor.
Okay. So what I can do, Mr. Kamba, is once we're done here today, I can print up that filed proposed order of parenting plan order. And let's see, I'm going to put that as file 222 of 24, parenting plan. And then I will print that and then sign that, and then I'll have it filed. So I'm granting your motion for the adequate cause, and I'm granting your request for the parenting plan. One thing I wanted to ask you on the adequate cause order on paragraph 6 says the petition to change a parenting plan or custody will move on to a full hearing or trial. I don't think that's necessary because I'm signing off on the parenting plan here today. So I'm removing that and then just saying that there's no further hearing needed because I've signed off on the parenting plan.
Now my question, Your Honor, she ran with my son.
Yep.
So how about am I going to get my son back?
It's a super important question, Mr. Kamba. The difficulty is that somebody who's not trained in the law, it's a cumbersome process, even for an attorney, and especially if the person's out of state with the child. I would strongly suggest you contact a lawyer. Some of your options include the Clear hotline. And I think I mentioned that to you before. I'm not sure if you did, but I can give you that phone number. Have you contacted them?
Not yet, Your Honor. I just needed to get all the court paperwork in and everything done so that we knew what was going on.
Yeah. If you have a pen handy, I can give you the phone number.
Okay, yeah.
It's 1-888-201-1014. And they're not open 24/7. They have some limited hours, but you can call that. They also have if you type Clear hotline in a web browser or search engine, it'll pull it up also, and it'll give you the times of when they're open, and it'll also give you some additional information about what's available. But it's a line that's staffed by licensed attorneys that can give you some assistance.
Okay.
Do you have any questions?
So, I mean, not really. Like, I thought this would like move forward into an assistance of me getting her back because she does have getting him back because she does have a restraining order on me.
Mm-hmm.
So,
yes, yeah. So at this point, the court has ordered that the child reside with you, and so the next steps is getting the child back and getting the child back to you, and that's a process that's somewhat more involved. And I think you're probably wise to get in touch with an attorney to get some help on that.
Yeah. So the orders that you're signing today, I have to come in and get them right, so that I have proof that it was signed over and everything.
Yeah, you can get a copy of the order that's a sign. It'll probably be 2 or 3 days before you can pick it up, but you can get a copy of that, and that shows that a court of law has awarded custody to you, and that you're the proper custodian of the child. Then there's the next steps of one, finding the mother and the child. A next step of getting some type of an order to take the child and return the child. It's a very involved process. You need counsel.
Thank you, Your Honor.
All right. Thanks, Mr. Kamba. Next, I have Stephen Utter and Kirby Young. I'll ask if Stephen Utter's on the line. Stephen Utter, if you're here, please unmute and state your name. Stephen Utter.
Yes, Your Honor, Stephen Utter.
Okay, welcome to you, sir. Kirby Young, are you on the line today?
Yes, I am.
Welcome to you, ma'am. And Mr. Lawrence is here as the guardian ad litem. So last time we were in court was January 31st. Mr. Utter wasn't here at that particular time. There's an indication that there hadn't been counseling sessions or had missed some, and there was a suspension of visitation until there was a greater showing of commitment to the reunification. I looked in the file yesterday, and I didn't see any updates as to what's happening with that. So I'll turn to Mr. Lawrence to maybe lead out, and then I'll hear from the other parties.
Your Honor, I had a chance to speak with Patricia Anderson, who is providing the reconciliation counseling this past Monday. I also received an email from Kirby Young on this past Friday, and Ms. Young had indicated that from Parker's perspective, she feels that Parker is resistive to the reconciliation counseling and does not want to continue it. And she is implying that to force him to do this is only going to be detrimental. Ms. Anderson had indicated that she found that Parker was somewhat reluctant in the counseling, a lot of very short 1- and 2-word answers, but she didn't understand that Parker wanted to stop the counseling at this point. I know that Mr. Utter has tried to get some kind of a relationship going with his son. According to Ms. Anderson, Mr. Utter has made the comment that, he doesn't want to force Parker into anything, and if he has to back away until Parker becomes an adult, then he would be willing to do that. Let him speak for himself on that. But at this point, I'm not quite ready to give up yet, Your Honor. Ms. Anderson and I have spoken, and they meet every other week. And so we thought if the court could postpone this another 60 days, that would provide for 3 more sessions. And if at that point things are not going anywhere, then we would be recommending to the court that the reconciliation counseling be terminated. And if there has been some movement, then we would ask it continue. So that's pretty much where we're at, Your Honor.
Okay, thank you. Mr. Utter, any input?
I concur with that. To more iterate on me stepping away, Patricia Anderson had told me it's better now. It's how did she put this? Instead of pushing away and never having a relationship with him, it's better to kind of stand off now in hopes, he knows I'm here, he knows I'm willing, I'm doing everything I can in hopes to have a relationship later. So I agree with that. I do think we've had minimal progress. The last time we were in there, we got some laughter out of him and stuff like that. He is very reluctant 1- and 2-word answers. But I agree with both Keith and her. I'm not ready to give up. There's something there.
Okay. All right. Thank you. Ms. Young.
So my biggest concern is obviously Parker. And great that Stephen is now wanting, his track record with Parker, 10.5 years absent. He's missed numerous counseling appointments with Parker, and it is hard on Parker. I'm willing to, try some more with this. It is a forced thing with Parker having to go. Just nothing with Stephen has been consistent at all. Even, the counseling. and we're trying to, I feel it's me and Parker trying to accommodate his schedule. It was originally supposed to be on Mondays, and he did 3 no-shows to those appointments. And then when we seen you on the 31st of January, he's made it to the 2 appointments where I've had to take Parker out of school to make it to these appointments for Steven's time. And I feel Parker and myself have went above and beyond to try to make this, relationship. I also will be Parker's voice, and he doesn't want a relationship with Steven. Again, willing to try. I don't know. I'm not very hopeful at this point, just with Steven's track record of absolutely zero follow through. Even trying, I don't know, I think it was last summer, we tried to come to an agreement with a parenting plan, and presented it to the courts, and absolutely nothing changed. He couldn't even follow that. Even his support payments are never on time. It was supposed to be a scheduled day, once a week or whatever. And those are never paid on time. I just don't want Parker hurt at the end of this due to his lack of. And again, I think Parker and myself have been more than fair to accommodate him.
Okay. All right. Thank you, Ms. Young. All right. I appreciate the update from each of the parties and the information from Ms. Anderson and Ms. Young and Mr. Utter and Mr. Lawrence. So I think it's premature to end the reunification counseling efforts, notwithstanding some of the past missteps or lack of consistency. It sounds like there's at least the last 2 counseling sessions have occurred. So we'll continue on with that path and see how things go. Obviously, children and parents are always children and parents, and I think a little extra effort is warranted in this situation. So we'll set the matter over for review on May 15th for the review to see how things are going. And we'll see everybody on May 15th, which is a Wednesday at 9 o'clock in the morning, if that works for everybody.
Yep, that works.
Okay.
It works for me, Your Honor.
Okay, Mr. Utter?
Yes, sir, that will work.
All right, very good. All right, I appreciate everybody's efforts. Good luck to you all. We'll see you on
Thank you.
Desiree Fierst, are you on the line?
Yes, I am, Your Honor.
Okay, welcome to you. I see Ms. Corey is here, the guardian ad litem, and then Christopher Zimmerman, are you here?
Yes, Your Honor.
Okay, all right, all parties are present. At our last court hearing, the court had asked the parties to submit information related to a graduated parenting plan and also information related to schooling and grades. I didn't see anything that was updated in the file related to that. We have the recommendations from the guardian ad litem, and so I'll hear from Ms. Corey if you have any updates.
Yes, I do. So these parties have basically come to an agreement. However, I have some serious reservations about that. I haven't yet seen the agreement, but at 8:18 this morning, Mr. Zimmerman indicated that they didn't have an agreement, and then just a few minutes later, I received a message that they did. I really have very little confidence that this agreement will stick, and I really want it to for these kids. So if I can refresh the court's memory that this couple's dissolution and permanent parenting plan went into effect on September 6th of last year. On September 22nd, just 2 weeks later, we were back at it again. Mr. Zimmerman filed for a modification at that point. But as I said, I haven't seen this agreement yet, but I do feel that I don't know that this couple are candidates for mediation, but either mediation or for it to go to trial is going to bring the best solution for the children.
You said mediation or trial would bring the best solution, you say?
Yes, I believe so. I don't think these parents, they had an agreed order before, and then 2 weeks after that was finalized, we were back in court for some very good reasons. And now there is this supposed agreement that came in at the final hour. And I guess I'm just not really buying that both parents are invested in this order and that's really what they want to go forward with.
Okay. All right. Thank you, Ms. Corey. All right. I see Mr. Zimmerman, you turned on your camera. Maybe I could hear from you first. let me just, maybe before we do that, Mr. Chairman, I apologize. There was the guardian ad litem report that was filed back in February. There was an order of adequate cause that was granted back in October of 2023. And we've been kind of working under that adequate cause order since that time. So the parenting plan is still at issue, just as probably more for my benefit to review that than anything. So Mr. Zimmerman, I'll hear from you. Looks like your mute's on, Mr. Zimmerman.
When I filed the motion for modification, due to the circumstances that were actually detrimental at the time, I filed those. And since the time of me filing those, I have noticed a significant improvement with Miss Fierce Zimmerman in regards to where her priorities are. She's found stable housing. She's in services. You know, it's been a complete 360. And so the reason I'm wanting to go with what Desiree and I have come to an agreement upon, because I was able to call her this morning before or after I'd spoken with Miss Twyla. I was able to have a conversation with Desiree, and we came to a verbal agreement. And I feel that it is in the best interest of the mental health of our children to finally get this done. And with what we came up with is, I think, the best outcome when it comes to my 13-year-old daughter, Sarah. She's at that age where any final decisions are going to have a major impact on her future as well as her mental health today. And coming up with the plan that I thought of, I feel that Mrs. Zimmerman and our communication has been absolutely phenomenal the last 2 months, and it just keeps improving. So that's why I came up with my idea for the parenting plan, and I would like to avoid going to any kind of trial if possible.
Okay. All right. Thank you. Appreciate that. So one thing to take into consideration is that the party submitted this decision and issue to the court. Obviously, as a general rule, the court feels that the parties generally are in the best position to determine what's going to be in the best interest of the children. However, there's some misgivings expressed by Ms. Corey that since the parties had submitted it to the court, I think the court has an opportunity to at least review what the proposed parenting plan that was discussed this morning between Mr. Zimmerman and Ms. Fierst. So my proposal, and I'll hear from Ms. Fierst as to her thought on this, is to have the parties draft up what your agreement is, what that parenting plan looks like, submit it to the court for review, and also submit a copy to Ms. Corey. We would come back at a different hearing date after we've all taken a look at it, and then make a decision if the court will sign off on that agreement. And so that's kind of where I'm going at this point. So we don't need to talk a lot about the specifics of what you've discussed and agreed to, but that would need to be put down on paper, a proposed parenting plan submitted to the court, so for its review, and then come back and take a look at it. So I'll hear from Ms. Fierst. Any thoughts on that?
Hi, Your Honor. Actually, we just wanted a continuance, just because with our busy life schedule, we just haven't had a chance to sit down and sign it to be able to make copies to turn into the courts. We have had a conversation and have come to an agreement. It's just trying to find the time to be able to sit down together to sign off on it to be able to turn in to the courts.
Okay. Would the parties be available on the 3rd of April?
I could make that work.
Okay, Ms. Fierst?
I will not be available that week.
Okay. What about the week prior on the 27th of March? Would the parties be present or available?
Is the guardian ad litem necessary if we're both coming from it?
Yes.
Okay. So what day?
27th of March, Wednesday, 9 a.m.
Yes.
That works for me.
Right,
Yes, I can do that.
Okay. So what I'm asking the parties to do is, since you had a conversation today, it sounds like there's an agreement in principle to submit a proposed parenting plan, submit it to the court, submit a copy to Ms. Corey, and then we'll be here on the 27th to review that. I also want an update from the parties, if you could submit some type of declaration indicating what's happening with schooling and grades of your daughter. I would appreciate that also. So then we'll come back on the 27th. We'll review that proposed parenting plan, and we'll go from there. Any questions?
No, Your Honor. Thank you so much.
Okay, Ms. Corey?
Nope, thank you.
All right, Ms. Fierst?
No, thank you for your time, Your Honor.
Great. We'll see everybody on the 27th. Thank you.
Yes.
Okay, welcome to you. And Evan Huffman, are you on the line?
Yes, I'm on the line.
Okay, very good. Welcome to you. Both parties are present. We're on today for motions related to temporary parenting plan. I appreciate the party's assistance with the efforts to move the case from Lewis County to here. I did receive that order from Lewis County transferring venue from Lewis to Cowlitz County. So I've reviewed the proposed parenting plan and input that you both shared related to Milo. Is that how you pronounce it? Milo, correct?
Milo.
Milo, got it wrong, sorry. Regarding Milo. So if you'd like, so we're here related to the parenting plan. So I would hear from each of you related to that, simply because the case is here as filed as Ms. Farrell, you being the petitioner. I would hear from you first, and then I would hear from Mr. Huffman, because he's listed as the respondent in this particular case. So I've read your pleadings, but I'd like to hear from you now. So Ms. Farrell?
I do try and offer visitation, but most of the time Evan does visits sporadically. Like on the same day, he'll just text me and be like, "Hey, I'm planning on coming and getting Milo today." And most of the time that doesn't work with me because of my work schedules and like other things that I have going on throughout the day. I keep trying to let him know to let me like have a couple days in advance before visits, but he hasn't done that.
Okay. And so your proposed parenting plan, let me just pull that up here. Maybe you could just review that briefly while I'm pulling that up of what your request is as far as the parenting plan.
I want to have one overnight visit with Evan and 2 full day visits.
Meaning one overnight for dad and child, and then two day visits per
Yes.
week. Okay, bear with me one moment while I pull that up. I just kind of want to look at the specifics. In your proposed parenting plan, did you list the dates and the times?
Yes.
Okay, can you, rather than going through the 81 pages here from the transfer, can you tell me what those days and times are?
Saturday is the one for, I'm sorry. Can you repeat the question?
Is it Saturday 9 a.m. to Sunday at 3 p.m.? Is that your proposal?
Yes.
And then Tuesday 9 to 3, and then Thursday 2 to 6?
Yes.
Okay. All right. And then do you drive? Do you have a driver's license?
No, I don't.
What is your proposal related to exchanges? Do you have somebody that could help you with exchanges to drive and pick up?
I do. I
Okay.
do.
You do? Okay. All right. Anything else, Ms. Farrell, you want me to know about?
Not that I can think of as of right now.
Okay. All right. Thanks. We'll hear from Mr. Huffman. Mr. Huffman, what's your position related to the parenting plan?
Hello, sorry. So for the parenting plan, I chose to do 50-50. Me and Hannah had talked about it a little bit, but she decided to not come to an agreement. So the original, I believe it was the temporary parenting plan, or it was the permanent parenting plan that I filed. It was 4 days, 3 days, 3 days, 4 days, um, for me and Hannah, and I have been doing, yeah.
Okay.
I haven't seen Milo in almost 2 weeks. There has been 2 different incidents where I've driven down to Longview, and me and Hannah have had a plan for me to come pick Milo up, and in those, it was on February 26th, and then February 26th, I came to get Milo, and then on the 28th as well, she said no. After I was already there.
Do you have a suggestion as to a location for the exchanges to occur?
Previously I just go over to her house, or one time she walked over to my dad's house, which is right down the road. So those two places is usually where we exchange.
So either at Ms. Farrell's home or your father's home, which is close.
Well, that's in Cowlitz County. That's in Longview, and I live in Centralia, which is Lewis County.
Right. So when there's an exchange of the child, I thought I heard you say that you want that to happen at Ms. Farrell's home or at your father's home, which are both here in Cowlitz County. Did I get that wrong or did I get that right?
Halfway would be what I would prefer. Hannah has asked me to be the only one to do transportation, so it'd be just it'd just help a lot if Hannah could get away with transportation because, she told me that she doesn't have any way to get Milo here. I have the text from her saying that.
Do you have a proposed location that would be halfway?
It's the space age or this. I think it was in morning. I think it was the Papa Bear restaurant. Papa Bear's West. That would be a good halfway point to me.
What city is that located in?
I believe that's in Chehalis.
Is that halfway between Longview and
No.
Okay. Okay. Other information, Mr. Huffman, you want me to be aware of as far as making a decision as to the parenting plan?
I just want to be able to see my son. Me and her have made a plan for me to see him, and she cancels the last minute. I just want there to be a fair 50-50 parenting plan in place for me to be able to see my son. She has said that I have everything for him. I have everything he needs. I can drive him. I just want to see him, and I want things to be fair.
Okay. All right, thank you. Ms. Farrell, any response?
Evan has, like I said before, has been very sporadic with visits, trying to do them on like the same day, like telling me the day of he's going to pick up Milo, which, doesn't work with my schedule. Evan has not helped with buying formula, diapers, or any clothes for Milo, anything that he's needed since almost he moved out. I mean, he has bought stuff for him down there, but Milo hasn't had a lot of visits down there, so Evan really hasn't been helping. I do have transportation every once in a while, but my mom also has 3 kids and she would be my transportation. That's why I requested Evan to do transportation because he does have a driver's license.
And you indicated that you would, if there was exchanges, then if it was a halfway location, then you would be responsible for transporting Milo, you or another getting Milo to that location. Can that happen?
Yes.
Okay.
As long as there's set dates and time.
Sure. Okay. Okay. Anything else on your end, Mr. Huffman? I'll give you the final word.
I really want to stick with the 50-50. I told Hannah that I'd be willing to start with 2 days, 3 days, 2 days, 3 days to start slow because she's told me that she wanted to start slow with Milo coming back here, but I haven't had any opportunity at all for him to come here.
Okay.
It's been about 2 months since he stayed the night at my house or my mom's house.
And are you living with your mom?
Yes.
Okay. All right. Okay. Well, I appreciate the input. We talked about this case a few weeks ago and pretty familiar with it and the different declarations that the parties have submitted. So I appreciate that. First off, the parties, both parents are fairly young, and I think this is first child for each, and there's a lot to be learned and a lot of growth that happens when you're first time parents, and it's compounded with difficulty when the parents aren't together, and they're separated. So There's also been some evidence of some fairly high emotions and high conflict related to, the past restraining order and concerns. And I think that is an indication to me that a 50-50 plan at this stage of the game is not workable due to that high conflict. Usually 50-50 plans or a residential split works best for the child if there's not that evidence of that high conflict. And here I think that there's fairly clear evidence of that high conflict. So I'm going to decline the invitation of the 50-50 plan for that. Having said that, Milo is very young and he needs to see both parents frequently and with regularity. That's really key to his development and well-being. So here while it's less than what Mr. Huffman is suggesting, I am going to adopt the proposed parenting plan that was proposed by Ms. Farrell that allows for visitation from Tuesday at 9 a.m. to 3 p.m. and Thursday from 2 p.m. to 6 p.m. and Saturday 9 a.m. to Sunday, and I'll change it till 5 p.m., just a little bit longer for dad to be with child. So that'll be the parenting plan. And then the exchange point, it needs to be a halfway point between the parties' homes. And I don't know exactly what that exchange point is. I mean, you could probably look at a Google map and put in both addresses, Ms. Farrell.
Yeah, so my parents are going to Vegas, like tomorrow for the next 3 days. And so I was going to offer Evan a visit because I will be out of town. But I don't have
When do you return?
I don't have any transportation for that visit, so Evan would have to come down to get him.
When do you return?
Sunday.
Sunday the 17th. Okay. Okay, and so what I'd ask, I'm not going to specify a halfway point. Generally, it needs to be a public place, usually like a rest stop or actually better, it would be like a gas station or a truck stop where the exchange could occur. And we'll make this the effective date of the parenting plan on March 18th. So that's Monday. That's when this parenting plan goes into effect. As far as child support, I don't have enough information to make a decision on child support. I need more information regarding incomes. I think I have a fairly good idea what Mr. Huffman's making, but I don't have much information related to Ms. Farrell's income or past earning capacity or future earning capacity. As far as the decision-making, I'm going to make decision-making joint related to health education and non-emergency healthcare. That means that you'll need to work through those issues and be respectful of each other. And what I'll do here today is usually what we do, we have the parties print out or prepare a proposed parenting plan. I think what I'm going to do, I'm just going to take that responsibility upon myself and I'll just produce my own parenting plan according to what I've said here today. And then I'll file that and then send copies to each of you. So I'll ask the parties if you have any points of clarification or questions related to the court's ruling.
I had 2 questions for you, Your Honor.
Please.
When would the parenting plan be able to be like changed or 50-50? Like, is there any possible way we'd be able to do 50-50 eventually?
Yes.
Yes. Okay.
Yeah, definitely. So what happens is this is a temporary parenting plan, meaning it's a temporary parenting plan. Once there's a final parenting plan in place, either you agree that you agree to a final parenting plan in the future, or it goes to a trial and the court would make a decision on that. So for now, it's a temporary parenting plan. So if there's ever a change you feel like that it necessitates a change of the parenting plan while it's in the temporary parenting phase, you can file a motion and ask for that. Once the case is once the case is a final parenting plan, then you need what's called a motion for adequate cause to change or to modify the parenting plan. But during the temporary parenting plan stages, then if you feel that there's a significant change or there's the reason to change that, then you can bring a motion and serve that upon the parties. Obviously, if you were to file something in 2 weeks, unless there's some huge dramatic change, we try to have some consistency for the child's well-being, but there's not necessarily any specific timeframes on that. So hopefully that answers your question. Okay.
Okay. And are you basing your personal parenting plan that you're gonna fill out? Are you basing that off of Hannah's parenting plan, but just adjusting it a little bit?
Correct. Yeah, I'm adopting the Tuesday 9 to 3, the Thursday 2 to 6, and the Saturday 9 a.m. to Sunday at 5 p.m. with the exchange location at a halfway point.
Okay. And then the last thing I wanted to say, it's not really a question. It's just based off of the child support. It's that was my old job. I actually don't work there anymore.
Okay.
And so I just wanted to let you know that.
So as far as the child support, since that's outstanding, I don't. Both parties need, if both parties are interested in addressing the child support issue, one party would have to file a motion for child support and then submit proper documentation and updated information. So it sounds
I'm
like
already
Mr.
working
Huffman,
with child.
hold on. So if there's additional information that Mr. Huffman has or any updates, he could submit that under seal as far as, like your wage stub or the like, and then Ms. Farrell would need to submit her information related to her income. Go ahead, Ms. Farrell, you had a question or comment?
Sorry, I was already working with child support, or I am already.
Okay, so there's two different things to keep in mind with child support. There's the administrative child support, and then there's a court-ordered child support. They're two different things. So you're probably aware of that, but just keep that in mind. So if the parties are interested in having a child support order, one or both of you would need to take action and ask the court to chime in on that and make a ruling on child support. So at this time, I'm holding off on that until the parties make a motion to the court for that purpose. Any questions, Mr. Huffman, Ms. Farrell?
No, Your Honor.
No.
Okay, so I have both of your addresses. Yeah, so let me just note that. Go ahead, sir.
So are you going off Hannah's parenting plan due to the charge against my mom, the false charge against my mom?
That is part of the reason, but not the sole reason. That was where I was talking about the high conflict issues. So that was part of the issue, but not fully. So I've got the address here, so I'll draft that parenting plan. I'll get that out to the parties. Any other questions?
No, that's everything. Thank you.
Okay. All right. So again, if you want the child support issue to be addressed, then you'll need to file something, have the court, and set a date for it. All right. Thank you. Looks like the parties are present here in the courtroom. They're coming up. All right. If you just position yourself in front of your respective microphones, that'd be great. We have Ms. Rhodes present and Mr. Robinson present, correct?
It's Jensen.
Ms. Jensen, thanks. So yeah, I apologize. I mean, once the case has been filed, it's kind of stays under that name. So my apologies.
All of the paperwork that I've written, it does say Jensen on it, but they asked me when I filed if he had a separate last name. And so because he has legally changed it a few years ago, I just provided that information to the clerk's office. Okay. But on all of the paperwork that's filed, it does say Jensen.
And that's your last name, right?
Yes.
Jensen, thanks. All right, I'll just make sure I refer to you as that today. I may err in the future just because it pulls up that way. We're here on Ms. Rhodes' motion for temporary parenting plan. And this is related to Nora, correct?
Correct.
Okay, so I'll hear from you. Go ahead.
So I got Chris's response on Friday. I did file a declaration on Monday, but I was not able to serve it to him because it just was so fast.
Okay.
I do have a bench copy available in case they were not able to provide that for you.
Is that 2-page declaration?
Yeah. So what I am willing to do is, now that Chris has obtained a driver's license since when I originally filed the paperwork, is that I would be willing, because he requested to have 2 weekdays from 5 to 8 p.m. and then Friday 7 to 7. I am willing to agree to that, but I don't think that I am capable of doing pickups for every time. So what I would like to propose would be that on the days that he is having her during the week, that he pick her up from her daycare center in Woodland. And then for pickups from on my end at the end of those weekday visits, as well as at the beginning and end of the visits on Fridays, that we can meet at the police station in Woodland. Just because that is kind of a halfway point, but my oldest, she has softball 5 days a week. So it's just really difficult for me to drive down to Vancouver 3 days a week, but I am willing to kind of come to a compromise on that, is kind of where I'm at with it.
Okay. Mr. Jensen.
I've not been staying in Vancouver. I've been staying in Chehalis. So that's the opposite direction. And when I gave her the papers, so when I first filed them out, when we came to court last time, I didn't know how to do it. So then I got it. There was a lot of things going on. I had to go to work. I went out of town for a week. I got in a car accident, totaled the car, I had to get a car. So all this before I filed that paperwork. And like, there's just so much in my head. I thought that this was going to be, I was thinking about like what I wanted. And I kind of went off of what she already had.
Mm-hmm.
But then after I filled out that paperwork, I thought about it more and I wanted to do every other weekend. So I went to work, printed out another sheet and I filled that out. But when I went to go turn in the papers, that's the papers I turned in. And I didn't know that till yesterday when she had texted me that she was saying that that's okay, is what I gave her previously. So I don't know what to do about that. Like, this isn't what I really wanted.
Okay, so let me make sure I'm following what you're saying. So Ms. Rhodes, you were proposing Friday 7 to 7.
I actually
So
completely would like to change that because if he's living in Chehalis, that means he's living at the house that with the girl that he met in rehab. And so I do have concerns about the safety of the fact that he just met this woman and they both have issues with substance abuse.
Okay.
So then that
Sounds
does
like-
change my
sounds like
opinion on
there-
things.
It sounds like there's not an agreement between the parties.
So there's no agreement. So my declaration I would like to completely get rid of because I had done that with the thought that he was staying in Vancouver, but I do not feel comfortable whatsoever with my daughter being around someone who also has substance abuse without there being
She
further
has
investigation.
substance abuse issues as well. We party together all the time.
So just let me just kind of lay some ground rules. So one of the ground rules in court is that when the parties are speaking, I let the party speak and I don't have other people interrupt them. So each gets to say their full say. At times I may need to interrupt. And so I kind of reserve that privilege for myself to interrupt, and apologies beforehand. So there were, coming into today's hearing, there seemed to be general agreement. It sounds like that agreement is evaporated and is no longer present. So I'm not sure. I read the response in the proposed parenting plan by Mr. Jensen. I did review Ms. Rhodes' brief 2-page reply today that she filed on Monday, but it sounds like things have changed. And so with kind of new information from Mr. Jensen as far as where he's living and the like. So what that tells me is that there's been some changes that haven't been made fully aware of, and that the parties maybe need to explore a little bit more themselves through declarations. And so I don't think we're in a position to move forward today. I do see that Mr. Lawrence is on the line too. So that's kind of where I'm at. So I don't think we're in a position, unless you want me to make a decision based on maybe less than full information.
I don't want that, but I do have questions about the child support and the childcare costs.
Okay. So as far as the parenting plan, Mr. Jensen, with
So right now we have a verbal agreement, and now that I do have my license, I would like to take her on Fridays, not have her at her house. So
yeah, so right now there's not a court order, so I'm not going to make any decisions on parenting plan today. So I think we need to have more information. Both parties need to submit a little more information to the court so I have a more clear view, because it sounds like things have changed with both of you actually. Related to child support, it's noted that it's on today for, let me just double check 1 second. Yeah, as far as the child support, that was requested in the motion. And I see that there was Ms. Rhodes submitted a financial declaration. And I'm not sure if we have much information from Mr.
I have not. I didn't know where to get that paperwork from. I did all the stuff for the parenting plan that I found on the. I talked to an attorney and he gave me a website to go to for that stuff.
Yeah, the courts.wa.gov, the forms section.
Yeah.
That's the place to find all the different forms, and you can find a financial declaration in there and submit that information. So that's kind of a preview, I guess, or a foundation to your question, Ms. Rhodes, related to child support.
Okay.
So I'll get that paper and then get it turned in, and we got court again not next Wednesday, the Wednesday after.
I don't think we have anything currently scheduled, do we?
We do.
Yeah, we have 2 more.
We got 2 more, yeah.
We have one in 2 weeks, and we have one, I think, a month after that.
That's correct, Your Honor. March the 27th at 9 o'clock and April the 24th at 9 o'clock. And then June, it appears, the 26th at 9 o'clock.
Is it June?
Did I set those hearing dates?
Yes.
They appeared on my order of appointment, Your Honor.
Okay. It just strikes me as odd when I hear future dates like 3 out there, but if it's the guardian ad litem review, okay, that makes a lot more sense to me. Okay. So March 27th, there would be a 30-day review of the party's compliance with, and kind of just making sure you connected with the guardian ad litem and payments going forward. And then we've got an interim review. So if the parties are coming back on the 27th, that's 2 weeks from today. We could address the parenting plan issues if you can get your declarations in quickly and then submit your financial information. Then we can address both of those issues on the 27th.
Sweet.
So Let me just double check with Mr. Lawrence if he has any comment other than what you shared.
Your Honor, I have made contact with both parties, Ms. Rhodes, primarily through emails, and Mr. Jensen. We have conversed on the telephone a couple of times. I have an appointment scheduled for a week from this Friday to meet with both the parties. It's going to be a little bit strange as I'm observing a visit with Nora by Mr. Jensen at Ms. Rhodes' home. So we probably won't get our initial appointments completed at that point, or initial interviews completed, but at least we're making contact and moving forward.
Okay, great. Appreciate the parties making good contact with Mr. Lawrence. So we'll be back here on the 27th. When we come back on the 27th, we're going to look for updated information from each of you related to the parenting plan, and we'll look for updated information on financials, so we can talk about child support.
So right now, am I getting the paperwork again and serving it back to her? She's serving it to me again? Are we just gonna talk about what we want now?
Yeah, so I have your proposed parenting plan. I have your proposed parenting plan. I don't know if that's changed.
Yeah.
So if it has changed, you'd need to resubmit to the court and also give a copy to the other side,
Okay.
and also to Mr. Lawrence. And then same thing with like financial information. You'd need to provide a copy to Ms. Rose and also a copy to Mr. Lawrence,
Okay.
and file one with the court.
Yes.
And then if you have any declarations about kind of providing explanations about the parenting plan or the child support, then you'd need to submit a declaration, file it with the court, provide a copy to Ms. Rhodes or to the other party, and also Mr. Lawrence.
Right.
Okay,
Great.
thank you.
Thanks.
Thank you, Your Honor.
All right, thank you. Kelly Johnson's motion for a temporary parenting plan involving, help me with the
Radiant.
pronunciation. What is it?
Radian.
Ridian. Okay. Right. That's cool. All right. So I've reviewed the submissions from each parties as far as proposed parenting plans and declarations and the like. Just want to remind you both, you probably don't come to court a whole heck of a lot. So there's a Cowlitz County Rule 88. It governs family law matters, and it gives out some good guidance as far as number of pages per declaration, spacing, and the like. So just be aware that, we had 24 cases on today. And so when people put it small font, single spaced, it makes it difficult. And then if it goes beyond a page limit, usually what judges will do is that they'll just stop reading once the page limit has been reached. So just aware, just kind of word to the wise in the future, just so you're aware of that. So it looks like Mr. Kenneth Johnson, you were served with all the documents from Ms. Kelly Johnson back on March 7th. So I'm making an assumption that the service was proper.
Yes.
Okay. All right. So I've reviewed that. So I'll hear from the parties. I'll hear first from Ms. Kelly Johnson, then we'll hear from Mr. Johnson.
Okay. So Ken brought up in the declaration that our insurance would not cover for the reunification therapy. I could submit to the court that he actually requested that it be referred out of Kaiser, so that way it wouldn't cover it.
So are you saying that Kaiser would potentially cover the
Yeah,
cost?
he specifically requested that it be referred out.
Okay. Okay, go ahead.
There was an incident between us last June. That's still an ongoing case.
Okay, if that's there. So I looked at that. I just want to just double check on that. There was
Self-defense in that.
so that's the pending, is it a pending criminal matter?
Yes.
Okay. And so let me just take a moment and pause here, just so everybody's clear. So because everything here is recorded, audio and visual, that anything that anything that any accused person or person who's been accused of a particular crime, anything that they say about that can be used against you. It's the right against self-incrimination. And so I just want to
I don't want to touch on anything on that
Right.
because it is still
Yeah.
an open case.
Yeah, I just want to advise the
He's
parties
using a
of
lot
that.
of his grants.
Yeah, I just want to advise the parties of that and just make sure that that's in your mind. If you're the accused person, you have the right not to self-incriminate. And if you do talk about the particular instance or the accusations related to the criminal charge, then anything that you say could be lifted, could be used in a criminal trial, and could be used against that person. So just thank you. Go ahead.
Okay. But there was, since I have been out of the house, I did bring up the pool incident. So all the kids, they ranged from 13 to 16. None were 17. Xavier didn't turn 17 until August, and the pool incident was back in June. The youngest was 13 and they were out there babysitting the 8-year-old at midnight. So it hasn't really been a lot of supervision. He's been working graveyards, so he's been leaving him on alone all night with his son.
And that's Xavier.
And that's Xavier.
Okay, exactly.
I will happily submit my medical records to the court. I already have submitted some because of that other case, but I have done a lot of therapy since the loss of my son. I have done many groups.
When did Everett pass?
He passed away 6 years ago.
6 years. Okay.
Yes, sir. For about a year, I was a train wreck afterwards. But then I really, really focused on helping my mental health. I have done DBT. I have done CBT, which is cognitive behavioral therapy. I have done 2 rounds of a group called Seeking Safety to address my PTSD. I worked actively with a therapist for 6 months after the June incident.
The which incident?
The incident we had in June, I worked with a therapist for 6 months after that.
And that's the June incidents. That's where the protection order originated.
Yes.
Okay. Keep going.
So Ken is claiming that I ignore my mental health and I'm not keeping up on it and I'm a train wreck, but I'd be more than happy to submit my therapy records to show that I've never been a danger to my kids. I'm not a danger to myself.
What's the status with counseling? Are you currently engaged?
I thought we were losing Kaiser, but I do still have a Kaiser therapist I can get back in touch with. I thought we were losing the Kaiser insurance from when he lost his job. But I can get back in touch with her. And I just completed a Seeking Safety group. That's what they call it. And it's to help with the complex PTSD.
When did
I
you
completed that in December.
December?
Yes, sir.
And then when was the last time you were in individual counseling?
December.
December also.
Yeah.
Okay. Go ahead.
He does bring up that falling out with my daughter. We did have a falling out. Unfortunately, that's really common after suicide. In April, Kenny was defending me against her, and then we had our conflict, and now he's like using her against me, even though 2 months before this conflict, he was defending me against her because she was lashing out at me so much, and she's just angry.
How old's your daughter?
She's now 21. I haven't talked to her in 5 years. And he submitted a declaration from Kylie. I haven't talked to Kylie in 5 years either. The declarations I submitted are people that I still talk to on a daily. But the people he submitted declarations from, it's been 5 years.
Okay.
They don't have an accurate representation of my mental health at this point. I did not have mental health problems before my son passed away. After he passed away, I lost it. And I worked really hard to bring myself back.
Okay. So right now the assault case is set for what's
April 5th is trial.
April 5?
Mhm.
And then which jurisdiction is the prosecutor?
Here.
Is it Cowlitz County?
Yes.
Okay, so it's Cowlitz, okay. And do you have any indication of what if it's planning to go, or if there's some resolution, or do you?
It's self-defense. I'm fighting it. I'm
Okay,
pleading
so-
self-defense.
Okay. And at this
I have a
point,
lot of, yeah, it's self-defense.
so at this point, you're planning that the trial will probably go on April 5th?
I think so, yes, sir.
Okay, all right. And you're asking, as far as your parenting plan, that you be nominated as the primary custodial parent, and then Mr. Johnson have alternating weekends, Saturday for 3 hours, and then like the next week, Sunday for 3 hours, and then Wednesdays from 8 till Thursday at 7.
Yeah, that kind of worked with, because his days are off for the middle of the week. So that would give him some visits on a weekend and then his days off to have him full time.
Okay.
Like that whole time off.
Help me understand a little bit, and you can chime in on this also. It related to Commissioner Carmi signed an order, the protection order, and she wrote in there, she said, until the family law court order makes a decision on visitation, we're here today.
That's why we're here, yes, sir.
Both parties complete reunification counseling to determine what contact should look like in the future. Dad, right? I put dad.
Yeah.
Mr. Johnson shall pay for the cost of reunification counseling.
He has not reached out to me at all since December. He has not answered any phone calls on Family Wizard except for the first one. And all I heard was, Ridian, do you want to talk to mom? No. And hung up. And I have not had no calls have been answered since then. They're never checking any of the messages on Family Wizard. He has not let me know. I just found out from the papers he served me that he even did anything with reunification, because he has not informed me through Family Wizard of anything.
So the reunification counseling is with you and Ridian.
Yes, sir.
You
But
said
he
yes.
said he would pay for it. So I guess that's why we're waiting for it to go through him, but
Okay.
now he's just not taking any steps to forward it, like do it.
Did you, with that court order, if sometimes when people have a court order and they feel like the other party isn't following it, they'll bring a motion and say, hey, this person's not following this court order. I want a contempt. I want to push them, make sure they do what they're supposed to do.
I did check
Have
into
you done
that. I
that?
talked to Cowlitz legal aid, and they did have me like fill out a paper, or she wanted me to fill out a paper, but the packet she gave me, it said it couldn't do that if I had like fought it within the past year. I've been trying to figure out what I can file against him because he's not following it, but being the person that the order's against, it doesn't look like I have very many. There's nothing I can really do to him to get him to comply.
Okay. Yeah, I mean, the order it doesn't necessarily specify who's to reach out to set things up. It's just, it's a little bit vague, so it makes it a little more challenging. Yeah.
Well, he's got the kid and he said he was going to pay for it. So, I mean, because Ridian's supposed to be there too.
Right.
So, I mean, I would be more than happy to do it. But yeah, I would be happy to set it up too, because I want it to happen.
Okay. Anything else at this point, Ms. Kelly Johnson?
No, I think that's it. Just the big thing that bothers me really is like that Kylie thing and the Kaylee. Like I said, it's just been so long ago that it's not an accurate representation of my mental well-being of now.
Are they both 21?
No, Kylie is an adult, but she's also a felon that ripped off her grandma for $10,000. Like, she's not the most honest person.
What are their ages? 21 and
Kaylee's 21 and Kylie, I think she's early 30s.
okay. And those are your two daughters?
No, that's his friend is Kylie.
Okay.
Kaylee is my daughter.
Kaylee's your daughter. How old's Kaylee?
She's the 21-year-old, but
Okay.
I haven't talked to her since 16.
Right. Okay. That helps. Thank you.
You're welcome.
All right, Mr. Johnson, I'll hear from you related to the temporary parenting plan.
So the swimming at midnight thing, I was not working at the time. I was home. Xavier was watching over the children in the pool, along with Talia, Katie, everybody was in the pool. I was home, so if anything did happen, I was there.
What was the youngest person there?
The what?
The youngest person.
Our 8-year-old.
The 8-year-old?
Yeah.
Okay. And then 8, and then was there?
There was a 13, I think Kate was 13. Arlen, my other daughter, she was there. She was 14 probably at the time, maybe 15. And then Xavier or Talia, I don't know how old she is. I think she's
Talia's 13, Katie's 14.
Okay, thanks.
Yeah.
I don't know how old they are. And then Xavier was 16 at the time.
Okay. And was there any injury?
No.
Okay. Go ahead.
And as far as moving providers, or I forget what she stated, but moving the counseling away from Kaiser to muck things up, that is incorrect. Kaiser gave me a list of providers because they don't do that type of counseling, the reunification counseling. So through Kaiser, they referred me to multiple places, which I contacted, had to set up intakes for, just to wait around to be told, we don't do court-appointed reunifications. So I reach out to the next place, wait for them to come in. With the holidays that were around that time, it was hard to get in. I didn't falter on anything. I reached out place after place after place. And then I went to multiple places. One was, I talked to Zach from Columbia Wellness, and he said, I guarantee you this person does it, Olivia.
Lovely.
And she's like, no, we don't do it, but reach out to Charlotte Rosin. She does it. So I finally got a hold of her. We set up a plan for a meeting time. And she said, our case is very unique in that she could set up Ridian for reunification, but it's not covered through insurance, which I thought it was, which is why I said I would pay, because it's insurance. I'll pay copay. She said it's $1,500 down and $1,500 retainer, $150 an hour or per session.
And that's not covered because she's not on a Kaiser referral.
Okay. So everybody that Kaiser gave me said they don't do it. So I had to expand out to find out who does it, period.
Okay.
So finding out how much it was, and then she says, we can't act as your third party because there's a no contact protection order. If you reach out to us to reach to her, that could be viewed as conflict. So Shannon would have to go in and contact her, file her paperwork, get in and start her side of reunification. So it's been a process to get there. And there is no stipulations on the protection order. It's a no contact order. So I'm honoring that. It didn't say to let her know what's happening with the reunification, not happening with anything. It's she can call Ridian Wednesdays and Thursdays at 6. And that's it.
Is that happening?
Yeah. She calls Wednesdays and Thursdays at 6. I respect Ridian. He has, and it was stated that if Ridian does not want to talk to her, he doesn't have to. It was verbally given to her by Commissioner Carney, and she understood that. Ridian does not want to talk to her yet, so I'm respecting that of him. The first time she did call, I put it on speaker like she said, and I said, Ridian, do you want to talk to mom? And he said no. And then she got on the line and said, I'm not supposed to be talking to you. This is just for Ridian. I didn't say anything to her. So I asked again, I said, Ridian, do you want to talk to mom? And he said no. So I hung up. So it is on him. He has access to my phone.
Ridian's 8?
Yeah.
Yeah.
Okay.
So not every week when Wednesday comes up, I said, hey, mom's going to be calling soon. If you want to answer the phone, and he has my phone, go ahead and answer it. If you don't, you don't.
Prior to June and in the episode that led to the criminal charges, what was the relationship between Ms. Kelly Johnson and Ridian?
So it's a mixed bag, Your Honor. So yes, she is a good mom. Okay, she is. Before Everett died. After Everett died, yes, she spiraled, had some issues going on. The problem is if we don't act a certain way at holidays, when we go out, she gets irate and she says, take me home, I don't want to do this anymore, or flat out say we don't want to do this anymore. She gets vulgar.
So let me ask you, just
it's a mixed bag. She's good until she's
so prior to that, that episode that led to the criminal charges, there's communication, they were seeing each other.
Yes.
I was his daily provider.
Okay.
Yeah.
All right. Thanks. Okay.
And then as things develop, we're walking on eggshells. We're trying to act the way she wants us to act, say what we want to say. And when she does lose control on things, I'm the one that says, it's okay, go talk to mom. And they don't want to. She scared them with her actions and what she was saying. They are scared to talk to her, but I made them go talk to her. And
So-
now I realize that was a detriment because I'm feeding into just, I don't care, your feelings don't matter, go talk to her.
Okay. What's happening as far as like with education of Ridian?
He is in country.
Okay.
It's local to our home.
Was there some indication that he was disenrolled for a period of time, or was that some? Did I
Not
mix
big
that up?
Xavier.
That's
His
Xavier.
older,
Okay,
his.
okay, that was Xavier.
Yeah.
Okay.
So Xavier, his mom moved to Kentucky.
Yeah, I don't need to hear.
Oh, okay.
Okay. I just wanted to make sure I was clear. Okay.
Yeah, that was a different child.
Just want to ask a question about I said alcohol evaluation and treatment ? And so there was something that I read that said, ask about that.
He accuses me of drinking, and it's all it is. There was a time, like I said, right after my son passed away, I did try to drown myself a lot of it for a minute. But I haven't drinking in years.
Okay.
Like, I don't drink. I realized that it was really bad for my mental health.
Right.
There was a time where in 2021, I had been suicidal, and I did try to drink to bring up the nerve to follow through. It didn't work. And I did 5 days inpatient, voluntary inpatient through Kaiser. And then I did an intensive outpatient program afterwards. And then I also completed a dialectic behavioral therapy course. So there was an instance where I used alcohol in a negative way. But now he's trying to say that I'm just this raging alcoholic running around drinking all the time. And that's not the case.
Thanks for your input. Go ahead, please.
And no, I'm not saying she does it all the time. I'm saying when she gets into a depressive state, when she drinks, she becomes very vulgar. She becomes very combative. and she will say a lot of mean and hurtful things to me, the children. And this last case on the 18th, yes, she was drinking prior to it. I have pictures of alcohol containers in our house underneath, in the backyard, underneath kitchen sinks. She was hiding alcohol, but she was drinking during these times. That's what, and when she comes out of these states, it's like nothing happens and we have to accept it and move on. It's very hard to do. We have to forgive and forget with nothing. Like, it's really hard to do. It's really hard to forgive that type of vulgarness. And
let me ask the parties just some more clarified questions.
Yeah.
There's some questions related to property and staying in the home. Are you currently in the home with Ridian?
Yes.
And do you have any objection to him Ridian staying in the home, pending a parenting plan coming out?
No, I'm fine with him being in the home. I think it's good for him.
Okay.
My concern is like he got rid of all my farm animals and didn't give me any of the proceeds from it. He has he's getting rid of my things. Like, that's my only problem with the home.
Okay, all right. And then as far as the Jeep Commander, you'd requested use of the Jeep
Yeah,
Commander.
and then
do you have the Commander?
I do.
Okay, all right. And then you had expressed concerns about changes to insurance, and I think that's related to the Kaiser concern that you raised earlier. Okay,
Yeah.
all right.
So to clarify, nothing about Shannon is removed from the home except for the animals, because I could not financially take care of them anymore.
Okay.
I did sell them and she did get half the proceeds for it. I put it in the bank. I gave all the animals to this lovely lady on the coast that has a farm and had pigs and chickens and ducks and all this stuff. So they went to a good home. I just didn't like, ugh. So it's meticulous. I'm not doing anything to get rid of her memory. All her pictures are up. Everything's still the same at the house. Everything's there.
Okay. Yeah, I think on a temporary basis, since we're here on temporary orders, issues such as, property division and the like, I'm not going to rule on that today. So that'll probably be in the future to kind of sort that out. Let me just double check that. Okay.
I would love for a GAL to come out and get the kid sides of things.
I'm sorry. Ridian is our only child. Ridian, there is no the kids. It's Ridian.
No, and I recognize that. And then there's also their step siblings, and
there is no step siblings. He's calling my daughter, his stepsister.
So does Xavier live in the home with Ridian?
Yes.
Okay. So sometimes when guardians ad litem interview children, there's it's a dynamic, right? There's a dynamic in a family, and so having contact and information from the full family members is sometimes important to guardians ad litem as they do their investigation.
Xavier is very jaded to me. What led up to this whole incident was him telling me to go effing.
Yeah.
So it wasn't that day. This was previous. So that's not part of that. He's very.
So the only reason I made comment about the guardians ad litem was in response to the statement by Mr. Kelly Johnson related to that, and the children, not child, not children. So I just was explaining that they may explore further than just the child that's the in common with the two of you. So
okay. He speaks. He will say where me and his son have a problem, and we have had tension, and then he'll just include like Ridian was involved in it. So it's very misleading.
Okay. So I think what I want to do at this point in time is that there's a lot going on with this case.
Yes. Yes.
There's been significant trauma with the passing of Everett. There's significant issues related to alleged crimes that have been brought forward by the state, and there's issues from fallout from potential from domestic violence and mental health evaluations and alcohol use or non-use. Right now, there's a protection order that allows for conversations to occur between Ms. Kelly Johnson and Ridian 2 times a week. I want to appoint what we call it's a family court investigator. Family court investigator is employed by the court to act as kind of a quick hit, dig in fast, get a more full picture than what I have here today. Then that family court investigator writes up, will speak to you and others, and then write up a report giving the court maybe a more full view from a third party view to get a better, clear idea on what the parenting plan should be, if there should be adjustments to the protection order, and if so, what that should look like, and what would be in Ridian's best interest. Because there's a lot going on, and with the April 5th trial date coming up, that could factor in on the court investigator's investigation. So generally, 30 days to 45 days is kind of the turnaround time I like to have with a court investigator, speaking with y'all and others, and then writing the report. You would get copies of it. We'd come back to court. I would have a copy of it, and you would each be able to chime in and share your perspective related to a parenting plan potentially being expanded or minimized or what have you. So that's what I'm inclined to do, is to appoint the family court investigator. Her name is Jennifer Schaefer, and she may be on the line. Yeah, I don't know if she's on listening right now. Sometimes she just listens in, but I'll make that appointment, and that's at no cost to the parties. Once she's submitted her report, then, since you raised the issue of guardian ad litem, there may be an additional appointment of a guardian ad litem that occurs at a later time.
Yeah,
And this is kind of a quick hit. I kind of focus and dig in. So that's where I'm thinking of going. And I'll hear from you both if you have any strong concerns or objections to that.
No, I appreciate it. Yeah.
Okay. Yeah, I mean, I have some ideas of, I think, I toyed with the idea of making a parenting plan here today, but I think there's enough going on that I want to, and also your parenting plans are pretty different. They're pretty divergent of what you're asking. So I want to make sure that there's kind of the nuance that I think that comes from those type of reports is presented to me, and then I can hopefully make a better decision that would benefit Ridian and be in his best interest. So let's look at a calendar. So Ms. Schaefer, Jennifer Schaefer, who's the family court investigator, she'll be reaching out to you, and there's nothing prohibiting you from reaching out to her.
Okay.
So if you call the court phone line, which is 577-3085, they can get you in touch with Ms. Schaefer. If you don't contact her, she'll be quickly getting in touch with each of you to set up a time to converse and the like. So what I'd like to do is set it over 6 weeks. Today we're at the 13th, 1, 2, 3, 4, 5, 6. That would put us at the end of April, the 24th of April. And if you want to check your calendars to see if you're available that morning, April 24th at 9 a.m. Okay, so we'll set that date as the review of the family court investigator's report, which will be at play the parenting plan and all aspects of that parenting plan. I have some financial information from the parties. I have some, net incomes and proposed. But if you have any additional information you want to share on that, feel free to enhance or augment the information that you've provided. Because if the court makes a parenting plan on that date and time, that it would likely be also a child support order could be entered at that time also. So with that said, let me just touch base with each party if there's any other items that need to be addressed today. Otherwise, I think we're finished.
No, sir, I think I'm good.
Okay, Mr. Johnson.
Just to be clear,
Yeah.
I'm not against her with the reunification. I think it's needed. I'm just asking that it be slow and in the best interest. That's why reunification, and I said part of the DV class that was brought up through an advocate, that she go through a DV course and give, but if there's a way to get some type of third person that says, yes, we think it's okay to slowly introduce visitations, that's what I'm looking for. I'm not saying it's horrible. I'm saying it needs to be slow and steady for the sake of Ridian, because he's scared.
And that, I mean, the purpose of a reunification counselor is just that. The reunification counselor will be there, and she may recommend that Ridian has his own separate counselor to help him work through things. And the reunification counselor is going to kind of be the one that's controlling all of that and looking at that. So I think maybe just one thing regarding Ms. Rosen, to make that clear, to get that ball rolling, I think probably a bit of nudge of that ball would be helpful here today if I were to do that. So have you paid the retainer?
I have not. So I was going to file through a motion that Shannon handles half, because I don't have $1,500 down or $150 per session for each of them.
Okay.
I said that, like I said, thinking that Kaiser was going to pick it up through them and I could just pay copays, but that's not the case.
Yeah.
So I was going to put a motion through on the protection order that either Shannon pays for her side of it or helps with half of whatever that's going to look like.
Okay.
Like,
Okay.
just, I do not have the funds to do that.
Okay, so I think that reunification counseling is a fairly timely issue, and the sooner we get that going, the better. When do you think you would be filing that motion related to?
I was gonna go to the clerks right after this and see what I have to get
Okay.
in order to make that happen.
Okay, so I would assume likely it would be noted up for hearing on that motion sometime prior to the 24th. So I'm not sure what the clerk's going to tell you as far as timeframes, but it's probably either the 27th of March or maybe the 3rd of April. So we'll probably see you before that, the April 24th date on that motion, so we can get that ball rolling. Because I think that would help the family court investigator if she had any information from Ms. Rosen, and she may not get it because it's, I don't know what Ms. Rosen's schedule is like and Radiant's schedule is like. So yeah, please file that motion if you want to have that heard. You'd have a response, and then we would be back here to address it. So we'll probably see each other prior to the 24th, but definitely we'll be here on April 24th at 9 a.m. to hear the family court investigator report.
Sounds good.
Any further questions before we break today?
No, sir.
No.
Okay. All right. Very good. That'll conclude the hearing for today. Latham, are you on the line? We'll see you on.
I am, yes. My audio good?
Welcome to you, Mr. Latham. And
Thank
is
you.
Ruby Engelbrecht on the line?
I'm not aware.
All right, Ms. Engelbrecht, if you are on the line, if you'll please state your name and make sure you're unmuted. Ruby Engelbrecht. Okay, so it looks like service was properly effectuated upon Ms. Engelbrecht back on the 23rd of February. So let's see. And I haven't had any response from Ms. Engelbrecht. Have you had any response yourself, Mr. Latham?
Your Honor, well, we've talked briefly about it. My wife suffers from pretty heavy substance abuse and mental health right now. She's in a pretty bad spot. So it's been kind of non-responsive, a little bit of combative about the whole process and the non-responsive. I even texted her recently as of a day or two ago about reminding her of the hearing, and just don't get a whole lot back from her, unfortunately.
All right. And it looks like as far as service, you served upon her notice of today's hearing, your motion for temporary family law order, the proposed temporary family law order, motion for immediate restraining order, copy of the restraining order, financial declaration, information on the parenting plan, proposed child support worksheets, order, proposed parenting plan, and a petition for dissolution. And did you serve a copy of the summons upon her?
I did, yes.
Is that in the affidavit of declaration?
I believe so. I'm not great at this process, never done it before. So I served her the full packet of everything I got from the clerk's office. I'm hoping that I did it correctly.
Yeah, the one thing that's as far as service, it looks like it gives a listing of the documents that you served upon her. And I mentioned all those different documents that were served upon her, but I didn't see the summons being served upon her because that box is not checked. So what it tells me is that the summons has not been served upon her. So that's kind of an important first step, that she actually receives notice of the summons. And because the summons, what it tells her is that, hey, you're seeking to end or dissolve the marriage, and that she has opportunities to serve you and also supply the court with a response. And it tells her she's got a deadline to respond by a certain date within 20 days of being served. So that kind of starts the clock ticking. And then if she hasn't been served within that period of time, then you have other options to pursue. But that's kind of a key document that really kind of puts this case moving forward.
Yeah.
So
and I might not have checked the right box, Your Honor.
Yeah, that may be too. And if you need to file some type of update to that particular declaration, you'd be free to do that if there was some error or of a Scrivener's error, what have you.
I'm taking note of that. So that would be go back down to the clerk's office and refile for clarification.
Yeah, if you made an error, then you could correct that error with with an amended or edited declaration of service. So I think what I'd like to do is hold off on moving forward today, just because I'm not sure about the summons issue. So we're still in court. We're in court right now. We're in court right now, so hold off talking. Thanks. So, Mr. Latham, what I'd ask is that if I don't know if your timeframes allow for, if you want to make an amendment to any of the pleadings. Oh, sorry. the sound comes right up here and my ear is trained to hear human voices. So thanks. So Mr. Latham, I don't know if your schedule, are you planning on doing that in an expedited fashion or what are your timeframes?
Yes, that would be advantageous, Your Honor. I just look to you for guidance on, clearly I did something not correct. I gave her the full packet, or my mom gave her the full packet. So she's gotten everything that I filed with the courts, so
Okay.
it's a 100-page packet. So if I did something wrong, I guess I'm looking for you to guidance on what I need to do and those steps, like
Okay.
what boxes do I need to check for them ending?
So the key aspect is the 20-day period from she needs to be served the summons. If she's been served the summons, great. If she hasn't been served the summons, she needs to be served the summons in addition to all the paperwork that you've already served her. One thing we could do is we could just set it on for a review next week on the 20th. And if we did that and you filed your amended affidavit of service, you could tell us that and it would be in the file. If you get it in by Friday, probably it could be in the file. And if you haven't, then we would look at setting a different date. But if we come back here on the 20th and you've amended the declaration of service, and that tells me that you have served her properly with all the documents, then we can probably move forward with your motion at that time. If you have not and haven't served her previously the summons, then on the 20th we'd have to find and look at a different date to set it out to.
And Your Honor, just for clarification, the summons is not for the temporary order, where the summons is for. Is the summons for the full dissolution?
It's all part and parcel. I mean, the dissolution, it involves a dissolution of property, debts, and parenting plans and child support. So it's all tied in together.
Okay.
So let's set it over 1 week to the 20th of March at 9 a.m. And will you do me a favor on that date? Because this hearing is not going to take long on the 20th. If you could just make sure that you could just chime in at the very beginning when I usually ask people if you have any strikes or continuances, speak up during that time frame and say, Your Honor, we just have this quick matter related to the summons issue. Can we address it now?
Thank you, Your Honor. It's a little new process for me.
So we'll plan on that. We'll set over 1 week to the 20th of March at 9 a.m. and we'll see you then.
Thank you. Thank you, Your Honor.
Thanks.
Take care.
That completes the docket and we'll go off the record.